Hello.
Hi, Adam.
Hey guys, I'm getting an error saying that my camera can't start, and I think I know what the issue is. Hold on, I was going to try to use another program to record it. Let me see if, and it looks like that's not going to work, but let me see if I can. There we go. All right.
Okay, sweet. I'm gonna let you take it for a minute, Adam. I'll be back in a second, okay?
All right, well, we're just waiting for people to arrive, so we're just going to hang out for a few minutes. I don't want to start before 6 o'clock, but thanks everyone for joining us. And as soon as Shane gets back, we'll want to share my screen because we've got some things to see here. But in the meantime, are you all able to unmute yourselves, or is that not possible? Maybe Shane is the one that's manning the controls here.
Yeah,
so.
We can unmute and remute as needed.
All right, great. So we're going to get started in just a few minutes. We got a lot to go through. It's going to be really exciting. So we will just wait another few minutes here for us to get going here.
And this is Adam.
Yes.
Oh, good microphones.
Oh,
yeah,
good.
people should stay muted until they're ready to actually say something.
Okie doke.
Yeah, sounds good. Yeah, if everyone starts talking at once, we may get a feedback problem. So hopefully that won't be an issue, but people are starting to file in here. So we're going to give everyone a moment here to get set up. And once it's 6 o'clock and Shane's back, then we can go ahead and get started. So I look forward to it. We've put a lot of work into developing an election reform proposal, and I think it came out just in the right time because it came out 2 days before the Republicans put out their plan, and I think that's a good time to have a conversation about what's in ours versus what's in theirs, what things we can do to really get off on the right foot, because the path that we're talking about doing is a citizen-initiated law, and that's going to involve a very big effort. We don't want to get people fired up and out knocking on doors for something that's not as good as it could be. So we're going to keep it going for another couple minutes here, waiting for people to arrive. So just welcome everybody. If you're just joining us, we're just going to give everyone another few moments to get into the room here, and then we will be able to show you what we've got here. So in the meantime, rescuemichigan.com, that's the website we're going to be looking at. That's our site, and that's where the plan lives, as well as the analysis we put together for the Senate Republicans' election reform bills, and we are going to go through them in some detail, so it should be exciting. So we still see people coming in. We're going to give it another moment here. We don't want to get off and running before we've had a chance to give everyone a moment to join the room. Hey, Shane, if you haven't already done so, can you make it so that I can share my screen? Because we're going to be needing to look at that pretty soon here.
Okay. 1 second.
Sure. And it looks like you've already got the recorder going, so that's good. Perfect. Because I think there's going to be people that didn't have the opportunity to join us tonight. Obviously, everyone's got busy lives, and not everyone can make a meeting that's happening at one time. So the recording will be essential. We had more participants register than are here now. I don't know if we want to give them more time, but it is 6 o'clock now, so I think maybe we should just go ahead and get started. If they come in a couple of moments late, that's not going to be a big deal or anything. So first off, let me just introduce myself, and Shane, you should introduce yourself too. For those of you who don't know me, my name is Adam D'Angeli, founder of the Rescue Michigan Coalition, and some of you I recognize I've been involved in state politics for quite some time, particularly with the focus on on grassroots organizing since I first got involved in politics back in 2007. I've been a campaign consultant. I've run campaigns for a number of successful candidates for the legislature, and I've had the privilege to work for people that I genuinely respect and admire, which is a tough thing in politics. But some of the people that I've worked for are Gary Glenn, who was a state representative for 2 terms. I helped out the campaign for Jeff Noble, who got elected in 2016. He served one term, and John Riley, who is still a state representative now, serving in his third term. I've worked in the legislature as a legislative assistant for more than 3 years in the Michigan House, and also a year in the U.S. House of Representatives. So I've done politics on both sides. I've been on the inside and the outside. And ever since the lockdowns began, I think that's when it really made more sense to be working on the outside again, because, well, first of all, nothing really much was happening in the legislature when things first shut down. But now especially, we've got a lot to do to get our state back on track. And what the Rescue Michigan Coalition is really all about is giving people the tools and training and resources to be able to maximize their ability to organize locally. And that doesn't just mean for election reform, it means for anything that you want to do as your heart calls you and as the political needs of the day demand. So what we do at rescuemichigan.com, one of the biggest elements of our website is that anybody anywhere in Michigan can sign up and obtain a voter file for their precinct. That includes not just the information you can get from public records like voter history and address information like that, but also very sophisticated voter information. In fact, we can take a look at that right now. Let me share my screen. Hey, Shane, I think you need to enable screen sharing for me. It says I'm the host, but it doesn't let me share my screen yet. So if you can figure out how to turn that on, that would be good. But in the meantime, while we get that going back to what we're doing at Rescue Michigan, obviously a big part of grassroots leadership is going to be working on local efforts, but it's also really helpful to have a major statewide project. And we think one of the most important things right now after what's happened in the election is election reform. It looks like, can I share my screen now? I can. All right. So I'm going to select the window here and share that. And okay, it looks like you guys can see my screen now. Shane, give me a thumbs up if y'all are seeing my screen. Excellent. So before we dive into the election integrity plan, I did want to briefly show off, since I was just talking about it, what the tools look like at Grassroots HQ on rescuemichigan.com. So once you've signed up, you can acquire your voter file. There is a nominal $35 to obtain it, but there's two aspects to that. One is we need to pay for these lists ourselves. And number two is we don't want the other side getting this information for free. So just to show you what some of these tools look like here, for any given precinct, you can download lists in various formats, and to show you, like, for example, very likely Republicans with activists and donors on it. And for between 1 and 3,000 voters in your own neighborhood, you can see their names, their election history, their GOP score, phone numbers, which elections they voted in. And there's actually a spreadsheet you can download that has even more information on it than that. We also have a tool for calling voters in your precincts, and we even made a tool for making November 2020 election confirmation calls. So we have lists of people who only ever voted in the November 2020 general election and never any other election in Michigan, and they're the ones that would get called first. So there's actually scripts. They give you an automated, they give you a voicemail script, they give you a routine to read. It plugs in your name and the voter's name, gives you the ability to record results. So all very cool stuff. And there's lots of other tools that I'd love to take the time to show you right now, but I think we've got a lot to get through on the election reform bill. So let's take a look at this. If you go to the action tab here, there's the election reform link right here. And let me start with this point before we get into the nuts and bolts of what our proposal and what the GOP's proposal says, and give you all some background information on why we're looking at doing something like this and what it all means. So the first thing to understand about what we can do to fix Michigan elections is there's, I would say, three major aspects of what we can do to make sure that what happened in 2020 doesn't happen in 2022. One aspect of that is individual actions that we can all take and what campaigns can do. And that means basically better grassroots training, better preparation and planning, getting more people signed up as poll workers, getting more people signed up as poll challengers, having more experience to know what to expect at the polls, how to document evidence, and so on and so forth. And these are all things that we can do. The other thing is litigation, and that is not my particular bailiwick, but there is still some opportunity out there for gathering evidence of what happened in 2020. There's still perhaps some opportunities for lawsuits, even criminal complaints. But again, that's not what I am an expert at, so that's not what we're looking at here. What we are looking at is what we can do to change public policy, what we can do to change Michigan law before the November 22 election, to make it so that the things that were carried out on November 2020 will be either a lot more difficult or preferably impossible to do. And that involves changing the state law. And when we talk about changing the state law, what we're really talking about here is what's called a citizen-initiated law. And for those of you who were involved in the Unlock Michigan effort last year, you're probably familiar with this. What it means is that if enough signatures are gathered in a 6-month period, and the actual number is, I think, 340,000 approximately, but in practice you have to go higher than that because not every signature is valid. Closer to 500,000 is the better number. If you collect that number of signatures, then the legislature can pass a law that would not be subject to the governor's veto. And I, for one, am of the firm opinion that anything worthwhile, anything worth doing, the governor is going to veto. There's been some discussion that the legislature has some ideas that there are some things that maybe the governor will sign into law. And if they want to be optimistic, okay. But I don't think that's very likely. The other option is a constitutional amendment. And that is a ballot initiative where changes to the state constitution are recommended. And if approved by a majority of voters on the November ballot, then the Constitution of the state of Michigan is amended. Now, there's a lot of logistical issues with that because that also means not just getting signatures, it also means winning on the November ballot. But even if everything goes our way, the first fundamental problem with that approach is that it wouldn't take effect until after November 2022 because you have to actually pass it on the November ballot first. So a citizen-initiated law is essentially the only thing where we can pass meaningful election law reform and have it in effect in time for the next election. So with that in mind, we looked at what we can do to improve Michigan's election law. And the first thing to realize about that is that a citizen-initiated law can only amend one law at a time. When a legislator requests a bill that requires multiple laws being changed, they actually have to get multiple bills. And that's why sometimes bills are passed as packages. Fortunately for us, most of the changes we want to make in Michigan's law is all in one law. It's all in the Michigan election law, although there are some exceptions to that. For example, one possibility someone mentioned to change the law would be to establish a specialty election court. And that sounds like a fine idea. I'm certainly not opposed to it. However, you wouldn't do that amending the election law. You would do that by amending the Judicature Act. So what we want to do is focus on everything we can do to amend the election law, because that's where we can make the most improvements on, is having a single bill that can be passed, that can be enacted by or initiated by the citizens, that if enough signatures are collected would be signed into, would not be signed into law, it would become law automatically by the initiation of the citizens and being passed by the legislature. And by the way, if the legislature fails to act, it would go on the ballot in November 22. But obviously the preferred course of action is the legislature would pass the proposal, and then it would be in effect in time for the November 22 election. So that being said, we're going to look at our plan first, and then we're going to look at the Senate Republicans' plan, and we're going to talk about them, and we're going to open it up for comments and feedback. So we set the time to be between now and 8 o'clock. I hope we will get through it all by then. If not, we can even stay late. We're here to answer questions. We're here to be open with everybody. But let's go ahead and get started. So this is the election reform page. And if you saw, what I did was I just went to this action tab at rescuemichigan.com and clicked on election reform. And here it is. Here's where we have the link to our actual proposal. But first, I want to just show you what we have here. This is just actually saying what I just said about a citizen-initiated law. And then there's this section about getting the policy right. Each of these items here, you can click on it and it expands out. There's a lot to it. So we made it so the page is easier to read by having this these little drop-down items here. And the way we came up with our proposal was to first look at all the problems that we saw in the November election. Of course, there was a lot of them. And then look at what we can do to change the law to enact solutions to them. So you see we've got problems, discriminatory selection of poll workers, unlawful impeding of poll challengers, issues with potentially counterfeit ballots, stolen ballots, the flood of applications that went out and perhaps false applications, chain of custody problems, voting without ID and signature checks, tabulation machine issues, the private political funding of public elections. The Amistad Project talked about that a lot. and elections being certified despite there being severe problems. And of course, we all heard about that with the Wayne County Board of Canvassers. So we're going to go through what we came up with, and we're going to look at the bill that we drafted, and we're going to see how each of those different things touches on some of these different issues here. So now I'm at the page here with the election reform plan. We put this out on Monday, and we're going to go through it line by line. Just a quick summary of some of the major items in the proposal. First of all, establishing clear procedures for genuine bipartisan apportionment in the hiring of poll workers. So as some background, and by the way, about me, I actually was a poll worker for the city of Detroit in the November election. In fact, I was a bit of a whistleblower on that. There was a Detroit Leaks audio recording that you may have heard. That was the recording of a poll worker training. I was actually the one that made that recording. I slipped through the cracks, essentially. A lot of people that applied to be poll workers were not able to become poll workers. They appear to have been systematically turned away. And part of the problem is that the Michigan law really doesn't have any meaningful enforcement of the requirement that poll workers be apportioned in a bipartisan manner. What the law says is that the clerks are required to hire as nearly as possible an equal number of Democrat and Republican poll workers. And the reason the law says that, of course, is because the people that passed the law understood that elections are an adversarial process. They are a competition for power in which real money and real public policy is determined by who wins or who loses the election. So there is an incentive to cheat. And when one political party controls who all of the workers are at a polling place, the opportunity to rig an election suddenly becomes higher. And of course, we saw with the wholesale impeding of poll challengers in Detroit, that's another issue that we had, was with poll challengers, who are also to be a check on the election workers and make sure they're doing things properly. But I'm getting ahead of myself here. Let's go back to the list here. Ensuring poll workers are informed of the rights of poll challengers and criminal penalties for infringing on them. Most people don't know. In fact, I didn't know before the election. It is a felony in Michigan to impede poll challengers. Actually, I think I did know that before the election, but it's turned out that's what they did. That's what they did in a wholesale manner in Wayne County and elsewhere on election day. Poll challengers, they had used the social distancing guidelines for COVID as a pretext for prohibiting poll challengers from being able to perform their duties, despite the fact that we actually prevailed in a lawsuit on the Wednesday before election day, in which the Secretary of State had agreed to back off of that policy, but they never carried that out. So that was one issue. Empowering election challengers and observers to document the evidence, the events that they witness. And of course, that's to building an evidentiary record and making sure that when crimes occurred at a polling place on election day, people have the resources to be able to document them effectively. Creating a uniform standard for meaningful signature checks and mandating their usage in all election proceedings. This is what the, I think it was the Carter-Baker report had said was the most likely avenue for election fraud was absentee ballots. And the number one way to prevent election fraud and absentee ballots is to have real meaningful signature checks and make sure that the people who are voting are the actual voters to whom the absentee ballots were meant to be issued. Well, we know that that was not what happened in Michigan in November. In fact, the Secretary of State recently just got defeated by the Court of Claims, saying that her policy of simply announcing that they could presumptively assume every signature was valid, had no basis in the law, and was enacted improperly in violation of the Administrative Procedures Act. Unfortunately, the court didn't get around to making that decision until it was too late. But all the more reason why we want to shore up this policy early and make sure that the signature check policy is well known and understood by all parties before the election begins. And that it's enforced uniformly. So we see for example, in California, the governor is suddenly a lot more sensitive to the signature check policy now that they're vetting signatures for his recall than they were when they had the general election. Of course, the same thing's going on in Michigan. We had no meaningful signature checks on voters for the election, but now we are seeing the Secretary of State going very carefully over each of those petitions that were turned in for Unlock Michigan to repeal the Emergency Powers of Governor Act. There has to be one uniform signature verification standard, and that is what has to be applied everywhere. Eliminating third-party absentee ballot applications. We all heard about this. Third-party private organizations were putting out absentee ballot applications. making the absentee ballot signature verification process open to observers and challengers. That's really the most important part of the absentee voter counting process, is the signature verification. And that was all done not at the absentee voter counting boards where we had observers and challengers, but days and weeks beforehand behind closed doors. So there's that component. Eliminating absentee ballot drop boxes. These were just introduced this past year. We don't need them, and they provide an additional security point of failure. We should just eliminate them. The fact that we have a 6-week plus absentee ballot period is absolutely absurd. Prohibiting ballot tabulars from being connected to the internet and providing for limited spot check recounts. Again, major security hazard, connecting a electronic voting machine to the internet where any number of things can go wrong. Obviously, bank fraud is a huge multi-billion-dollar criminal industry. There's all kinds of security hazards associated with things being on the internet, and providing for spot check recounts so that people can verify that the machines are faithfully reporting the results as they are provided to them. We're going to look at how we go about doing that in a moment here. Implementing the ballot tracker program statewide. That's to allow absentee voters to confirm whether or not their ballot was returned, so that they will know if they voted that their vote was received, or if they did not vote, but somehow their vote was received, then something very, very serious has happened. Tightening ballot chain of custody procedures and requiring security features for ballots. I'm sure you guys have seen stories about absentee ballots that were counted that somehow were never folded, which is strange because you got to fold the ballot to put it in an envelope. Creating a process for county canvassers to rescind certification if made under duress. And again, just I think the very day after the Wayne County Board of Canvassers had certified the election results, they attempted to rescind the certification on the grounds that they were pressured intensely to have certified the election. They wished they hadn't. And of course, the Democrats were all too giddy to say that there was nothing they could do about it. It was too late. Creating a process, I just read that one. Allowing facts to be determined in quote unquote unrecountable precincts. We saw in the August primary election, I think it was over 70% of precincts in Wayne County, or at least the city of Detroit, were out of balance. And I think it was still up to around 40% in the general election, which is an absurdly high number. And what might have been the issue there, other than just incompetence, although that's a possibility at least, but hey, it'd be racist to say that, wouldn't it? So let's just assume that it was malicious intent, because one of the things that happens if a precinct is out of balance is that it cannot be recounted. Now, there's a reason why we have that policy, which is that if a seal is broken on a ballot box, for example, there's a possibility that ballots were inserted after the fact. That's why they have that policy. But the converse of that is that therefore a precinct is not recounted at all ever if a seal is broken. So we're going to look at how we address that. Extending requirements for retaining ballots and other records so that when there is post-election litigation, there's a preservation of the evidence. And finally, prohibiting private entities from funding public election officials. So those are the essence, those are the major provisions of our proposed bill. Before I continue on, Shane, if you want to just let me know, do I still sound okay? I don't know if we want to take any questions just yet, or if people have their hands raised or how that works. So let me know if you want me to keep on going, or if you guys have any questions before we move further. Hey, Shane, are you there?
Yeah, I'm here. I still there's some comments in the chat, but if anyone has any questions, feel free to leave them in the chat right now, and then we can address them. I'll do a brief introduction for myself real quick. My name is Shane Trejo. I'm the 11th CDRC chairman. I've been working with Adam for almost a decade now on various different things and doing everything that we can to rectify the many problems that happened in last year's election and make sure nothing like that ever happens again. We're trying to put forward the most comprehensive reform that we possibly can. We salute the lawmakers in Lansing who are doing what they can to reform the elections, but we want to make sure that their efforts are as comprehensive as they need to be, and that there's nothing that allows the Democrats to find exploits in the law and do stuff along those lines to destroy our elections, steal our elections, and take our country away from us. So that's what we're trying to do here at Rescue Michigan. And Adam is going to explain still a lot more to explain this very interesting on how you can use the database, and not just for election fraud, but on any other issue as well. Right now, I am not seeing any questions right now.
Yep, I do have the chat open here, and Shane, I apologize for not introducing you at the beginning. I really should have done so. So thank you, Shane. And Shane and I have worked together for many years. He's an absolutely outstanding activist and a journalist as well. So if you don't already, check him out at bigleaguepolitics.com. Please do so. I do see a couple of questions here. One thing people are asking is Pat Kolbeck here, and is he connected to this organization? Not yet. That doesn't mean that we're not open to that. In fact, he's by all means welcome to come join us on this call tonight. And if not, we are going to still likely reach out and see that we coordinate on policy. In fact, the reason why we released this proposal as what we call a public draft is that we want to have this conversation with everybody and to have really the best minds looking over this and seeing what we left out, what things we can tweak. We're going to be looking at the state party's proposal, and just the same, we're going to see there's some things in there that we certainly like. There's some things in there I certainly have concerns about. So we're going to talk about some of those things too. And I fully agree. If we are to proceed with a citizen-initiated law, it has to be something that everybody's on the same page about. So that's what this process really is. Briefly, people are I see a question here. I'm going to answer this before we proceed, then I'm going to move on, but I will come back for questions again later. With respect to HR 1, which is the federal left-wing election bill. First of all, I don't think that bill is likely to pass. It is already having serious problems in the Senate, and not even just among Republicans, but also among Democrats. If it was signed into law by the president, so, well, not my president, but if it is signed into law and it becomes in effect, there is serious doubt about how much of it is actually constitutional, because it wildly infringes on state election laws. So the future of that is uncertain. But I would say, nevertheless, we want to do everything we can to make sure that our state law is correct. We want to do as much as we can so that no matter what happens in Washington or in the courts, we do everything that we can, that we have the ability to have an impact on. So, all right, with that said, let's get started. We're going to go down through it here. By the way, there's also this video analysis on the page, which goes through kind of the same thing I'm about to go through right now, which is go through the bill line by line. That video is 1 hour long. I will try to keep this one a little bit shorter, but there's a lot to it. As mentioned earlier, the purpose of this being one act is that that's the only way we can do it with a single citizen-initiated law. So you see in the preamble here, actually it's called the title of the bill. It's covering a lot of different elements of the Michigan election law, but all of them are amending Michigan's election law. There's a link here to offer your feedback. So we are encouraging people, send us what your recommendations are, what things we can do to make this proposal even better. Because as I say, we don't want to proceed until we've given everybody the opportunity to make the bill the best bill it can be. So there's these passages in here, which I'm going to skip over because I'm basically narrating them right now. In this case, it's just explaining that this is the title of the bill up here. And lastly, that the reader should notice that a lot of the language that we're about to look through is actually the pre-existing law. Whenever a section of law is to be amended by a bill, you have to write out the entire section. So all this stuff here, this is part of the existing law in section 31 of the Michigan election law, which is MCL 168. So we just scroll down through here till we get to some of the first changes. And here's another informational piece here for those of you who haven't seen legislation before at the state level. Legislation is drafted by the Legislative Services Bureau, and what they often do is they have certain changes to style over time. So you'll see them do things like they're crossing off shall and writing in must. They'll cross off them and write in the clerks. You'll see them change person to individual and so on and so forth. They do this all the time. It doesn't actually change what the law does, but we make ours do the same thing, because if it does become a citizen-initiated law, we want our bill to match as closely as possible the bill the legislature would write. So that being said, here we go. We're going to get to the first major provision of the bill. This is at the section discussing the curriculum for the training of election workers. And what we're adding in here is that the training must include, but not be limited to, both of the following. Number one, information on the rights of election challengers to conduct their activities in accordance with section 733, and that any violation of those rights is a felony. I'd mentioned this before when poll challengers were impeded. People didn't know that impeding poll challengers is a felony in Michigan. And that's a very big deterrent if only people knew about it. So we want to make sure that poll workers are trained to know the rights of poll challengers. And there may, by the way, this is an example of, a provision in our bill where we're thinking, what else could we put in here? What else could we require that poll workers be trained to know? So there may be more stuff in here that we want to pound on too. So this is one area to look at. What else could we put in here? But that in and of itself, I think, is a huge one. The other thing is that later on in this bill, you'll be seeing a requirement that election workers all have to wear identifying name tags so that if there is a problem, such as them being criminally impeding poll challengers, that their victims, which is what a poll challenger being expelled from a polling place improperly is, has the recourse to know who they are, to know how to file a police report. They have to be able to identify themselves. So that has to go into the poll worker training as well, to know that they have to wear badges at all times, and that failure to do so is a misdemeanor. Next, we see the same thing here. This is for precinct inspectors. This one's for election officials, but same thing. Requirement that they understand the rights of poll challengers, that infringing is a felony, and that there's a badge requirement. All right, next element. The genuineness of signatures for individuals signing a petition. So what we have in here, not later than 90 days after the effective date of the amendatory act that added this section, 90 days after this bill becomes law, pursuant to the Administrative Procedures Act, the Secretary of State shall promulgate rules for a uniform standard for signature verification for election officials to use when verifying a signature on an election document. That means it goes through the entire rulemaking process. That involves public hearings, public comment, a legislative review period after the final language is adopted, and then the actual signature verification policy is accessible and understood by the public. We also have a restriction that any revisions after the first must take effect only in the first half of the year, essentially before an election, so they can't change the policy at the last minute. And also, notably, we put in that the election documents we're talking about includes voter applications, absentee ballot applications, absentee ballot return envelopes, and a ballot petition. So you remember I said earlier, they seem to have different standards when it comes to petitions they don't like versus the voter applications. It should all be the same standard, all be one thing. So that's why that language is in there. Now this little bit here, remember I'd mentioned earlier, they're doing a lot of housekeeping, crossing off shall and writing in must. Here they actually are crossing off may and writing in shall, and this is a change. This is an important one. Right now, there is not actually a requirement that signatures be verified, and we're going to be changing that. So in the current law, it says the Secretary of State may capture or reproduce the signature of an elector when they register for a driver license or when they apply to vote. And we changed that from may to shall, because they should be always checking signatures. They should always be verifying signatures every time. And that starts with actually having a signature on file to be able to check against. So that's here. We're changing from may to shall. They have to collect the signatures, so they'll have them on file to compare them to. All right, what do we have here? We're crossing off that if an election signature contained is available, no, always, at all times, the election official shall compare the elector's signature upon the application with the digitized signature provided by the qualified voter file. If an elector, in current law, it says if a voter's signature is not contained in the file, they process it in the same manner anyway. And if voting registration lists are used, they shall determine if the name on the application is the same name. If the signature does not correspond, the voting individual must be challenged. We're making clear these should all be challenged. They're all subject to challenge under section 727. So there's no wiggle room here. Not if the signature is contained is available to look at, then they got to compare them. No, they have to be compared every single time. Okay, section 672A. This is the name tag requirement. We talked about this earlier. Between 7 a.m. and 8 p.m. on election day and at all other times while in his or her official capacity, an individual appointed as an election inspector must wear a badge identifying the first name and last name, and it's a misdemeanor not to. All right, next section. This is a big one. This is about the partisan apportionment of poll workers. Now, I mentioned this earlier, but this is something we really need to go into. The problem we have in Michigan's election law, well, not in the election law, but the problem we have in general is that wherever they say you have to have a Democrat or a Republican or have an equal number from both parties, there's no real meaningful way to know if someone is a Democrat or a Republican. And this is going to be a big problem in the redistricting commission, because that's what they have in that proposal, which is now in their constitution. You have a certain number of Democrats, a certain number of Republicans, and a certain number of independents. Well, for the huge majority of Michigan people, you don't know if they're Democrat or Republican because Michigan does not have partisan voter registration. So I've heard people from time to time say, I'm a Democrat, I'm a Republican. They'll say, I'm a registered Democrat or I'm a registered Republican. No, you're not. There's no such thing. The only exception is if you're a precinct delegate, but that's not most people. That's only like one in a few thousand. So without partisan voter registration, if you have a redistricting commission where they say, we need to have 6 Democrats and 6 Republicans, well, anyone can just say, I'm a Republican, and there's no real stopping that. So what we looked at as a way to address this, because this is what happened in Detroit. They appointed as nearly as they could an equal number of Democrats and Republicans, but they just get people who filled out the application calling themselves Republicans. That's all they have to do. There's no way around that. There's no meaningful enforcement. So here is our recommendation. Give the county parties first crack at saying, these are people that we want preference. So subject to subsection 2, the Board of Election Commissioners must give the following individuals described in subsection A first priority. Those individuals who are on a list submitted by a major political party under section 673A have filed a properly completed application to be an election inspector and are qualified to serve as provided under section 677. So the idea is that if your county party says, here are people that we know are Republicans, they should be the first ones they hire. And under this provision, that would be their obligation. They would have to give those people first priority. So when Wayne County or the city of Detroit says, oh, sorry, we don't need y'all. We already have our applications all filled by 19-year-olds, 18-year-olds, 17-year-olds, 16-year-olds. No, the party gets first priority in picking who they'd like to be actual poll workers. So that's first priority. And second thing is registered and qualified voters over non-registered and ineligible voters. I'd mentioned this. This was an obvious thing that the city of Detroit was doing. When I took my poll worker training, they told us flat out, huge numbers of electronic poll book inspectors, the people behind the laptops, are going to be underage minors. They're going to be people that actually can't stay overnight at the receiving board to turn in the laptop because they're not 18 years old and their work permit doesn't allow them to work after 1 o'clock in the morning. So we'll need to find someone to do that job for them because they can't do it. So what the city of Detroit was doing was bringing in ringers. And we should put a stop to that right away by saying, first you hire people who actually are registered voters, the people who have the most interest in the outcome of the election, because the election is an adversarial process. And that's just being truthful about the matter, that we want to have the people who are running the election, the people that actually are eligible to vote, qualified to vote, registered to vote. And finally, within all those categories, they have to appoint randomly. So they can't just say, oh, we've already hired everybody that we recruited to the local high school through God knows whom they found to perform that task. Once you have a given number of applicants, and one of the things that you'll see later in the bill is that you have to establish a clear opening and closing date for when applications can be received. So they can't just say, sorry, we've already hired all the people we need. They then have to choose from the people that applied randomly. All right, next we got this provision here. Let's see what we're looking at here. Okay, this is what I was just talking about. This is the timing window for applications to become poll workers. At least 40 days, but not more than 90 days before each election, each city and township clerk must post notice on the city or township website and post notice at the city or township clerk's office regarding the application process to be a precinct election inspector. And again, this goes right back to the city of Detroit. I don't know if you all read my affidavit about this, but when I applied to be a city of Detroit poll worker, I tried everything I could to apply. And originally, they had no online application on their website. In fact, they never had an online application at their website. They had a secret link that was not posted there that they were giving out through back channels. And eventually, someone in the know sent it to me, and that's how I was able to apply. But the members of the public had no way of knowing where to go to apply online, which is the only applications they actually looked at. I actually also applied to be a poll worker by hand. I filled out an application. It did not have an email address to submit it to. So I ended up driving all the way to the Wayne County Clerk's office and handing it in myself. Never got a call back, not until after I submitted the electronic application. So they have to post a link to where to apply online, and there has to be a particular window of when applications are to be received. And then not before that date expires, then they go about hiring based upon first the priority, first to the parties, then to registered voters, then to everybody else. All right. And again, every city and township has to have an online application process. That's right there. And now here's one. Beginning on the effective date of the Amendatory Act that added this section, and i.e. after this becomes law, each ballot used at an election must include security features to prevent duplication, including but not limited to use of color inks and microprinting. And here too, there may be more specifics that people come up with for how we would make sure that a ballot is secure. And of course, the obvious comparison is our currency has these kind of security features for a reason. Ballots don't at all. They have nothing. They could be, and in fact, there's actually a story in the New York Post that came out in, I think, last spring from a professional election criminal who stole a number of elections. And he said, one of the techniques we used was we'd intercept ballots, steam open the envelopes, replace them with our own. So very important that ballots have some kind of security features. And here's where I think the more detail we put in here, the better. But at the very most basic boilerplate level, let's at least say they would have color inks and microprinting. And I think we should have probably even more in there. Here's another one. Political parties and other entities should not be providing compensation to people to become poll challengers. This is from the testimony of witnesses to the TCF Center debacle, that it appeared the Democrat Party literally just paid people off the street to get rowdy and make trouble and start a mob. So prohibiting the compensation of poll challengers and make sure that the people performing the serious duties of being eyewitnesses and being a check on the election process are actually serious people who are not just being hired heavies. Okay, and here, this is a clarification about the impeding of poll challengers. It is a felony in Michigan. The language here doesn't really change the penalty. It just specifies that it's a felony. We heard from some attorneys that said they weren't sure whether or not it was a felony. Their understanding was ordinarily the rule is any crime where the penalty can be as much as more than a year in prison is a felony automatically. But some attorneys said they weren't sure that was the case. So we just clarified, yes, it is a felony. We want to make sure that there's no disputation about that. So that's just the clarification there. Small element here, just to make sure there's some documentary evidence. Each poll book must include the name and political party affiliation of each election inspector appointed to that election precinct. Election inspector, by the way, is just a synonym for poll worker. That's what it means. Your standard poll worker. It should be a matter of, it should be in the record exactly how many were from each party so that this can be looked at and considered. And then now we're starting to get into absentee ballots. So first part here, this is a big one, crossing off by a written request signed by the voter. That's what all those third-party applications for absentee ballots really were considered to be. They weren't the official government form. They were a form made to look official by private entities, and they would be processed because this statute right here basically says anytime the voter has a written request signed by them, then that counts as an absentee ballot application. So first thing we're saying here is no. The application for an absentee ballot can only be one of two things. Either the federal postcard application, which is provided for in federal law, or on an absent voter ballot application form provided by the clerk of that city that includes the city or township logo embossed on the application. So not easy to forge. An applicant must sign the application, and now here we have the application voter ID. An applicant for an absent voter ballot must either present identification for election purposes to the clerk or attach a copy of the ID. And if the applicant doesn't have identification, then they can sign an affidavit. However, that affidavit that we'll look at in a moment would be issued a provisional ballot, not a regular ballot. There's a big difference between a provisional ballot and a regular ballot. So Yes, they still can sign an affidavit rather than presenting ID. But if they do so, they're going to get a provisional ballot, which means it's not counted on election day. It means they have to follow up and actually verify with the clerk their identity in, I think, 6 days after the election, or else the ballot's not counted. So a provisional ballot is not automatically processed. There is a much higher level of scrutiny. They have to actually go back and verify after the fact. And then here, subject to the subsection, a clerk or assistant clerk shall not deliver an absent voter ballot to an applicant who does not present identification or the affidavit. So it's mandatory. And then this is the part of the section where they demonstrate what the application should look like. And here they add this language in here. In addition, you must either present identification for election purposes to the clerk of the city or township in which you were registered, or attach a copy of identification for election purposes to the application. If you don't have ID, you may present to the clerk an affidavit, but if you present an affidavit, you'll be issued a provisional ballot that is subject to verification and is not tabulated on election day. So just as I had said. And then here we say a city or township clerk shall only accept an absent voter ballot application from an elector as described above. So they can't accept applications that are not issued by themselves or by the federal postcard. And here's this language again, just another part here. This is talking about overseas voters. And then here again, this is the same thing again. Same thing, and then there's just a lot of pre-existing language here. This is the same thing again. And same thing again. And now we get to a large section of things that are struck out, and that is all relating to the absentee ballot drop boxes. Oh, and here also, this is where they're changing from a challenge ballot to a provisional ballot if they send an affidavit rather than presenting ID. Okay, so absent voter ballot drop boxes are not permitted for use in this state. An elector must return his or her absent voter ballot as provided in the instructions for absent voters. So all this stuff struck out. This is what they put in relating to the drop boxes. And simplest thing to deal with the drop boxes is just get rid of them. We didn't need them in the first place. We have an absurd 6 weeks of an absent voter period. That's more than enough time for people to get a ballot in. So that's all that. Okay, next thing. The clerk of a city or township must record on each absent voter ballot return envelope whether it was delivered personally or whether it was sent through the mail. And they may not accept mail that does not contain a postmark, because mail without a postmark is fraud. This section, this is the ballot tracker program. We talked about this at the beginning. We're changing what is optional to what is mandatory. Instead of saying if a city has access to the ballot tracker program, then the clerk will utilize it. Now it says each city must have access to the ballot tracker program so that voters can verify whether or not their ballots were received, or if somehow a vote came in from them that they didn't actually cast. This is the same thing again about the provisional ballot for those that don't have ID to vote absentee. Okay, this next section is on ballot security measures for absent ballots. They have to be contained in a secure container. They can't just be in a pile on a desk. I have seen that at a clerk's office before, where the absentee ballots were literally just in stacks in boxes on a cart. And anybody with access to that office potentially has access to those ballots. I mean, they're sealed, but envelopes can be steamed open. It's not hard. So it's a chain of custody issue. Ballots should be kept in a secure container. And the description of that is contained in this section here. Then we've got further down, we've got more existing law here. Let's keep scrolling, scrolling and scrolling. Here we go. Okay. Next thing, videos. If there's not actually voters voting at a polling place, these meetings should be open to video. They are public proceedings, and videos are capturing the documentary evidence of what's occurring at these events. So at any absent voter counting board, an election inspector, challenger, poll watcher is authorized to use a video camera to videotape or record the proceedings. And then at least 14 days before an election at which they're going to be, oh, this is another thing. This is the bit about requiring that the signature verification is in an open to the public process. So anytime there's going to be an absent voter counting board, at least 14 days, the clerk must post public notice of the location, the time, and that includes when the counting board will meet to verify signatures. So wherever they're counting signatures or verifying signatures, it has to be open to the public, and it has to be announced at least 2 weeks in advance, so the public is able to be present and to confirm that things are being done properly. The time and location at which the signature verification process described in this section occurs must be open to election challengers and poll watchers. So there it is right there. What else do we have here? Here we go on the voting, the ballot tabulators. They may not be connected to the internet. That is added as a requirement in this section here. Let's see what else we have here. I think I might have just passed over something that looks small but was big. No, maybe not yet. Where we changed the, oh, there it is right here. Allowing the ballots to be destroyed after 30 days. No, 180 days is better. Let's give them some time to work through the process here. Next thing, if 5% or more of the precincts in the county are out of balance, and each of those precincts are out of balance by more than one vote, the Board of County Canvassers for that county must not certify the results of any election or for any officer or proposition in that county. It's a big one, folks. If more than 5% of the votes in the precincts are out of balance by more than one vote, because we'll give them one vote, that's just human error, the Board of County Canvassers must not certify. This is, I think, this would be the first provision anywhere in the state election law that actually says when canvassers do not certify an election. Right now, it basically implies that they have to certify them no matter what. And of course, that led to a lot of the confusion that happened in this past election. In this case, the canvassers have the fallback to say, no, the law actually says we can't certify this election because more than 5% of the precincts are badly out of balance. All right, this is a bit about rescission. If the Board of Canvassers completes the canvass, announces their determination, but if the member signs an affidavit that their decision was made under duress, they can rescind it. And if that rescission changes the outcome of the certification too is rescinded. So that gives, for example, Wayne County Board of Canvassers an opportunity to rescind their certification of the election if they realize that that was the better course of action there. Next thing here, all ballots used at a primary or election must be retained and may only be destroyed after 180 days, so giving plenty of time for courts to examine evidence. And this is the spot check recounts we talked about. Each political party, the county chair, can decide after the election, one precinct, one race, to have the ballots opened up and looked at and recounted. So think about how this would impact any potential hacking of an electronic voting tabulation machine. The hackers wouldn't be able to know in advance which precinct anywhere might be the one that gets recounted. So they can't safely assume any of them won't be recounted. So if the machine is stealing, I don't know, even 10%, flipping any number of votes, it'll be immediately obvious. And by the way, for anyone that hasn't done a recount before, I did a recount in 2016. And every single ballot that we saw, the machine counted correctly. It's remarkably unusual for a machine to not count ballots correctly. Every time we had a discrepancy, it was because there was like someone put an X over a vote they meant to take back, and the machine had absolutely no way of knowing if that was right or wrong. So if 83 counties are conducting spot check recounts, it would make it impossible for anyone to be able to manipulate the votes reported by the machines without being subject to being exposed. And of course, the county parties are going to choose whichever precinct they think is most likely the one where they're going to find something. So there's a provision for spot check recounts right there. Moving on. Okay, informational recounts. This is what we were talking about earlier about how precincts were rendered unrecountable. If a precinct is off by even one vote under current law, a precinct can't be recounted. The ballot box is never opened again, never looked at. Well, our solution to that, because I mentioned in the beginning, there is a good reason why they have that policy. What they don't want to have happen is for a ballot box seal to be broken, ballots to be inserted after the fact, and then when the recount occurs, they say, "Oh, look at all these, there's all these other ballots in here," and to have that be the official total. That's why they have the law the way it is now. But the obvious problem with that is that therefore you can intentionally have a miscount, precinct out of balance, or a broken seal or something, and now the originally reported results are never going to be questioned again because you can't look at the ballots. So we change a lot of language here. You see here, not recountable is crossed off in this paragraph. What all this serves to do is to create a process for what we call an informational recount, which is to say that if a precinct is out of balance, you still do recount the votes in the ballot box. However, they don't automatically become the new result of the election, but they can be considered by a court. So a court can decide, does this seem like an instance where the precinct was just off by 1 or 2 and these votes should be counted, or should they not be counted? So all of these changes here are done to accommodate that change in policy, that there is now an informational recount. And also because, you know, if they're only off by 1 ballot, that's probably just human error, or maybe it's intentionally just making the precinct unrecountable. So if it's only off by 1, we don't need to count those. So yeah, if recount has done an informational recount, the Board of Canvassers conducting the informational recount shall accept all the previous returns. So it's saying the informational recount doesn't automatically count. Must not be used to change the result of the election except by a court of competent jurisdiction. Next thing here, this is all just still part of that same thing, the informational recount. More about the informational recount. Okay, final thing, we've gotten through it, and then we'll open up for some questions. An election official shall not accept from an individual or entity, either directly or indirectly, any of the following: a gift of money, a gift of property. Doing so is a felony. So keeping private funding out of public elections, and that means any of these things, and it includes their offices too. So that's what we've got here. So a lot of elements in there. We talked in the beginning about what all these we're looking to address. And again, just to recap at the very top here, we looked at a lot of different problems that we saw, what we could do about it. So we've got genuine bipartisan apportionment of poll worker hiring, advising the rights of poll challengers, empowering challengers to document evidence, signature checks, single party only absentee ballot applications, signature checks being open to the public, no drop boxes, no internet connection for tabulators, spot check recounts, ballot tracker program, chain of custody issues tightened up, canvasser rescission, unrecountable provision, precincts still allowing facts to be determined, document retention, and prohibiting public and private entities from funding public elections. So a lot of stuff in one bill. And at this point, my throat's already getting dry, but we're going to open up for some questions. And Shane, we would be happy to hear from people. Obviously, I could just read off the questions in chat, and I will read the questions if people don't ask them out loud. I prefer we open it up, make it a little more interactive here. So.
Okay. Yeah. For people who have questions, just hit the raise your hand in the reactions. You should be able to raise your hand if you have a question.
I saw someone raise their hand, so feel free to call on anybody.
If you're the host, so I think you can call on them. I see Mike Mayday has.
Okay. Well, I'm looking at my screen too, and I'm looking at chat. Let me see here if I can tell you. Let me stop the screen sharing and go back to the, okay, now I see people. So how do I'm new at this. How do I see whose hands are raised?
Click on the participants. Click on the participants. People with their hand up should flow to the top.
Gotcha. Thank you, sir.
No problem.
All right. Mike, are you there?
Hi. Yeah, it's Mike and Donna.
Hey, Mike. How you doing?
Good.
Okay. 2 quick questions. One is, I know we were talking about connection to the internet, but is there any concern about Wi-Fi capability, about there being shenanigans if it's Wi-Fi capable? And then the next question is, do you have any senators that even care that we're going through all this?
Well, I know we have senators that care, and we're going to look at their proposal very soon, which they've clearly put considerable work into. As for Wi-Fi, Wi-Fi is connecting to the internet. So prohibiting them being connected to the internet also prohibits Wi-Fi. Yeah, I would assume every senator cares about ballot integrity, or maybe one way or the other, depending on what their party affiliation is. But yeah, the Senate did put out a list of a set of 39 different proposals. So we're going to look at those next. So happy to go through those. And we're going to compare and contrast some of the very same things that we have in our plan are in their plan too. Some of the things that we have, they don't. Some of the things that we don't have, they do. So we're going to look at both of those. And this is really the beginning of the whole process. We put out our proposal as a public draft because we want to get feedback from everybody. We want to see what things people have concerns with, what things people think could be added in. And I think the legislature is going to be doing the same thing. The next step in the process after introducing the bill is going to be committee hearings. And that's the first opportunity the public has to weigh in on what they think of the legislation, what things they want to add, what things they don't want to see, and so on and so forth. So it's an ongoing process, and it's really just kicking off now. The first step was getting the plans laid on the table, and now we've gone from 0 1 week earlier to now we've got 2. So thank you for that. Let's see, Randy, what's up?
Hey, Adam, how you doing? Can you hear me okay?
Hear you great.
Okay. Here in Antrim County, I wanted to let everybody know that our lawsuit is still ongoing. And the Secretary of State has been intervened into the case as a defendant. The Attorney General's office is representing her. Our attorney, my attorney, Matt DePerno, and Bill Bailey's attorney has subpoenaed 8 counties. Clerks have been served subpoenas in Wayne, Macomb, Oakland, Livingston, Barry, Charlevoix, Grand Traverse, and let's see, the one I left out. No, that was the 8. Wayne County and Oakland County have both made a motion in courts in their counties to squash these subpoenas, to be allowed to do forensic accounting audits like we did here in Antrim County. Major problem, the case is in Antrim, Judge Kevin Elsenheimer. His subpoenas were relevant to discovery to this case in our county. They have to deal with Judge Elsenheimer in the 13th Circuit. They chose to try to get a local judge in their liberal counties to squash these subpoenas to do forensic accounting audits. The reason they want to squash it is we have the evidence, Adam. How many counties, and you and I were down in the basement of the TCF Center on election night, when 1:30, they all went to dinner, they all went to lunch until about 3:40. That happened in multiple counties around our state. What happens during that 1 hour, 2 hour shutdown where their machines magically fail, they have a problem, the system went down or whatever, is when they check the reporting numbers based on counties that have already reported in. The algorithm kicked in and started shaving votes in my Antrim County at 1:37 a.m. About the same time you and I were watching everybody go up the escalator to go to lunch. We must, and I will fight on this point, any reform packages must include no reporting to any media, no reporting to the Secretary of State, no reporting of any numbers until all 83 counties are fully 100% reported in. $50,000 fine, 5 years in prison, felony for every offense. If you leak these numbers out to the media, if you leak these numbers out to the New York Slimes, New York Times had my Antrim County as being blue before my own county website did. How did they know that? And what happens, we're just the lonely hicks in the sticks north of 46 up here. But every single year, we go to bed at night winning everything. All 82 counties are in except for Wayne County. And sure enough, we wake up in the morning and find out that everything is flipped because Wayne County finally reports in. We must have this point in there. I don't care if the candidates don't like it. I don't care if the parties don't like it. I don't care if consultants don't like it. No reporting of any numbers in until all 83 counties are 100% reported. And any clerk that leaks out information about percentages of reporting in their county, it's $50,000 cash fine to them personally, no governmental immunity, and 5 years in prison. That's how you'll stop the fixing in the algorithms from triggering and shaving these votes in these counties, because all the machines, Dominion, ES&S, and Hart, all have the same capabilities of doing it. And we have the evidence here in Antrim County.
Well, I look forward to seeing what happens next in that court case. That's for sure. And yeah, recommendation noted. I will say, I think one of the issues that people are going to have is that precincts, individuals in precincts often report what they can the moment the polls close, or when the ticker tape comes out of the machine, I guess you could say.
Yep.
And I don't know how you can control for that, but I do appreciate the comment. We got one more hand raised, and we are at just past 7 o'clock, and we also still have the entire Senate proposal to look through. So let me call on William, because I think he had his hand raised first, and then I see a Robert Brines, but it doesn't look like Robert to me. But let me start with William. Are you there?
Yes, I'm here. Can you hear me?
Yes.
Okay. Another thing that I think needs to be addressed is, as far as fraud, is we need to put some kind of provisions in to force any local prosecutor or even the Attorney General's office to prosecute or investigate any instances of fraud that are pointed out. Because right now we can point out fraud all we want, but with this Attorney General, she's not going to look into anything.
Well, actually, believe it or not, the current law actually does have a duty to prosecute in statute. So there may be yet an opportunity for someone to file a civil suit against a prosecutor for failing to do that. But that actually is in the law. So question is, will any litigants step up to do that? And again, as I said, litigation is not my bailiwick. I'm looking at the policy. But yeah, if you look at the election law, I don't have the number off the top of my head, but it's near the end of the Michigan election law. They actually do have a duty of police to file charges for any credible allegations and election law violations, and prosecutors have a duty to prosecute them. And the remedy for a prosecutor failing that is a civil action against the prosecutor. So that is a distinct possibility. I want to take one more question from the Brines, and then I do want to keep going. We will go late if we need to, but I also want to try to mind the time and try to get everyone out by 8 o'clock. So
Adam, could you get
yes.
Ken? Could you get Ken's after this too? Because he'd been raising his hand for a while. Ken Shack.
Oh, sure. Yeah. Okay. Sure. Yeah. Go ahead.
So my question is, when we worked at the TCF, we were told that we were part of a counting board. Well, at our counting board, nobody seemed to know what the precinct numbers were for that counting board. We did 6 ballots for 2 days. Now, don't you think part of the problem in TCF is the size of that place, with all those precincts coming into one place and you can't tell what's going on the second floor? Why did they allow them all to come together under one building, one roof? And then it causes major problems just being there that many people. Why aren't they? I realize that parts of Detroit are bad, but there has to be places where smaller numbers of 1 or 2 precincts. We have one here at St. Pat's where there's 2 precincts here. But to have that many under one roof and then have one table counting them all, that's part of the problem right there.
That is a good suggestion. The legislature in their plan has something about increasing the number of poll challengers, but I like your idea too. So that's definitely worth considering. I do also think the provision about video recording would be helpful, because that will make it easier to document evidence and sort things out. Yeah. So thank you for that. All right, Kenneth, and then we're going to look at the legislature's plan. Ken, you're muted. Hold on.
Sorry about that. Yeah.
There you go.
Just real quick about voting records. Hey, I know Jocelyn and the bunch have said they've cleaned a lot of records, but I know for a fact they're not all clean, not only here in Troy, Michigan, but also in up by Roscommon. And I don't know how you feel about that or how much that plays into this whole scheme, but is there anything that we're going to do about addressing requirements to cleanse voting records or whatever? That's this question.
Well, tell you what, we're going to look at some of those in just a moment. The legislature's proposal has some of that in there. So I think there's elements of that they've already got covered. So tell you what, let's go check that out now. And then we'll come back and take more questions after that. So I'm going to go ahead and share my screen again. How do I, hold on, looking for, this looks like the one. We're going to look at the legislature's proposal. So we got, I made an analysis. There's 39 bills in here. In fact, I think I can open up a tab in the legislature's webpage here and we can start looking through them. I think they start at 273, I think. Let's see. Yep. Okay. So this is the first of 39 bills. I am going to try to plow through these fairly quickly because there are so many of them. And some do more than others, some do different things. This one, in fact, maybe I should go back to my list here because this kind of summarizes all these. You can see this on our blog at Rescue Michigan. We just have these short summaries. So this first one, Senate Bill 273, this is adding regulations for absentee ballot drop boxes. It says that if an absent voter drop box was used prior to the next election, in other words, was used in 2020, it must be approved by both of the following before the next year, the Secretary of State and the Board of County Canvassers. And if it's not approved, then it must not be used at an election after that. It also specifies that a clerk must use a video recording device to monitor the drop box. Our proposal, we just did away with the drop boxes entirely. That seems simpler to me.
Adam,
but they instead
Adam,
have, yes.
Sure. As you're going into each of those, could you please copy and paste the link of the page where you're going through these into chat? That way people could save the chat later and review and get all the links.
Sure, and I'll just show, sure, and let me just show you what I did here. I went to the main page on the legislature, their homepage, legislature.mi.gov. You can delete all the stuff it puts in. If I just go to legislature.mi.gov, you just type in the bill number. And they start with 273. We'll look at the next one, 274. You can actually just cycle through them with these navigation buttons here. They're all in sequence, so I'm just going through each of these here. So I didn't have much to add on the bill we just looked at. It provides regulations and security devices for absentee ballot drop boxes. Like I said, we have a 6-week absentee ballot period, and the drop boxes are just as point of failure for chain of custody. So I prefer to see them done away with altogether, but that's what that bill would specify. Senate Bill 274, pre-registration. Anyone who is 16 years of age but less than 17 and a half years of age can pre-register to vote. And they go through a whole process for what that means. Essentially, it says when they become 17 and a half years of age, that's when it gets processed as a ballot, as a registration application. So there's a little regime here for explaining how you would go about pre-registering to vote at age 16. I am not aware of why there was a problem with people just becoming 18 years of age that did not register to vote in the 6 months before turning 18. So I'm not clear what problem this intends to address, but that's Senate Bill 274. Get more people registered to vote early. That is what the bill does. All right, Senate Bill 275. This one is for election audits. And this allows for video recording of audits. This was not in our proposal. I like this one. I don't know how much of an issue it is for audits, but we talked about video recording the proceedings for the absentee voter counting boards. This one applies it to audits, so that seems good to me. I don't think this one does anything else, and it does not. So that's what that one does, video recording of audits. Next up, Senate Bill 276. This one is also video recording. This one appears to be in a different manner of wording than ours. I would say we could go with either one or maybe both, depending on, we'll have to compare the two. But this one's clearly doing the same kind of thing. It says any precinct absent voter, that's a difference. Theirs covers live in-person precincts. Now, I would say politically, that's probably going to be a tougher road to travel, just because the opposition is going to say this is intimidating voters. This is disenfranchising voters if you do this at polling places. I don't buy that, and I will tell you, I worked at a polling place in Detroit on election day, where 200 people cast their ballots in one precinct, and probably as many cast their ballots in 5 other precincts under one roof. And there was absolutely zero concern for privacy of voters. And matter of fact, the secrecy sleeves of the ballots were too short. Everybody's ballots were exposed. I was a ballot box inspector. People were handing me ballots all day long outside of the envelope, which didn't know at the time. Sure wish I had. The actual proper procedure for that when a ballot's exposed is to throw it in the garbage and say, have a nice day, sir, you can't vote, you exposed your ballot. Because that was happening all day long, at probably every polling place in the city. And in fact, about the middle of the day, a videographer, a documentarian for, I think it was ABC or NBC Nightly News, came into the polling place and was video recording, and not one single voter cared. So it's a left-wing talking point that doesn't actually have any value, but that's what they say. But anyway, so going back to this bill, it says any precinct, counting board, or other location where votes are tabulated, they are authorized to record video. So I like this a whole lot. I think this is great. I think it might be politically more difficult than some of the other provisions that they have in here, but if the legislature is up for it, hey man, have at it. I think this is great. So good, solid bill. So let's move on to the next. 277. This bill, let's get to the meat of it here. Okay, yeah, this bill increases the frequency of when records are updated. So instead of saying once a month, it says every 2 weeks, and then it also says in the run-up to the election every week. The clerk shall send by email a list of last known address and birth dates to everyone over 18 years of age who has died. They have to compare that list with the voter registration records in the city or township and with the qualified voter file, and cancel registration of deceased voters. So increasing the frequency of updates, good stuff. I believe that's all we have in here. Also requires some disclosure here. Information on flagged voter registration records posted on each county website gets posted to the Secretary of State website, so that would be available to the public to see. So good stuff there, solid transparency, like that. Very good. Senate Bill 278. Senate introduced bill, here we go. This looks like it relates to drop boxes again. Yep, more regulation of drop boxes. This one specifies who is authorized to collect the ballots and how they must take them directly to the clerk's office. Certainly nothing wrong with that. Should be the process anyway. Not sure if there's a strong enforcement mechanism for this, but at least they're establishing it that it's going to be in statute. So again, my preference is they do away with the drop boxes altogether, but if not, more regulation of them. Not a bad thing, not a negative, but there it is. So that's 278. Next bill, 279. Here we go. This one.
I have a quick question.
Yes.
So the bills that you're going through, I was told by Brenda Nora that there's like House Bill 4127 through 4135. Are those different?
Yeah, I think we can look at those as well. I don't know if those were part of the the GOP plan, they called it, I think, because the state Republican Party put out a news release about the Senate package the day it came out on Wednesday. The House plans. Give me a bill number again. I can take a look at it right now.
4127 through 4135. Those are the ones I've been looking at.
Okay, this has already passed the House. Let's see here. Placeholder date of birth. Placeholder date of birth. This is in reference to the ones that have a birthday of 1/1/1900.
Right.
Looks like they're correcting that. I did not see this in any of the Senate bills, so this looks like it's different. We can go through these two.
Okay.
So I'll put them on the list here. So yep, I'll come back to that one.
And I believe that it's Rep. Bolin who's leading the House in approving the first round of bipartisan election reforms.
Yes, and it looks like she's on the call tonight too.
Yeah.
And I would just generally say, what can we do in a bipartisan manner? Great, but the heavy lifts, the controversial stuff is not going to be bipartisan. I think it's one of the biggest myths of elections is that they are not an adversarial process. The fact of the matter is, when you are competing for power, both sides have an obvious interest in manipulating the rules, and the pretension that, oh, we're just doing this in everybody's best interest is what the Democrats always say. And that's the kind of thing that we got to go on the attack on. Because if we're doing things that are actually going to prevent ballot fraud, Democrats will fight them tooth and nail, every single one. So there may be some things we can do in a bipartisan manner, and that's fine, but the heavy lifts are not going to be bipartisan. So anyway, we'll come back to those in a little bit. Senate Bill 279. This one's to expand the number of poll challengers in larger counties at absentee voter counting boards. I think I referenced this earlier when we were looking at, I was answering a question about what we can do to maybe make the AV counting boards not as large as they are in certain cases. What this is doing here is, let's see what we have here. It increases the number of challengers. So for any number of counting boards where they're counting more than 2999, so 3,000 or more, they add challengers, or how many challengers are eligible to be challengers. So every 3,000, they add one more challenger is able to be on and participating. And I don't know if it's this bill or another one that also specifies that, I think it must be in a different bill, that challengers are allowed to swap out. Because one thing that they did at TCF was, if a challenger had to leave because they'd been there all night, they weren't allowed to be replaced. And I think they fixed that in, oh, it's right here. Any challenger designated replace another challenger must meet the requirements. So yeah, they can replace challengers. So yeah, that's right there too. So good stuff, good bill. And moving on. Senate Bill 280. This is regarding citizens petitions, things like Unlock Michigan. And this, I think, aims to tighten up on the counting and processing of signatures. So it says the Board of State Canvassers shall complete the canvass of an initiative petition within 100 days after the petition is filed with the Secretary of State. So they're putting a deadline on where there is not one now. There is one. I think the deadline is the July before the election, where it would appear if it was to go to that. But in the case of Unlock Michigan, had we not won at the Supreme Court days after those petitions were submitted, the Secretary of State was basically going to sit on those petitions for over a year. And that's no good. So they changed that, and then they changed the deadline for filing the petitions from 160 days to 200. That's to give them that 100-day window. So that's what that's about. So that's to address that. Another solid bill. Good work. Look at the next one. 281. Let's see what we've got here. This is relating to voter registration records. Not later than March 1st of each year, the Secretary of State shall request information from each recognized multi-state program or service that they're participating in to verify current residence and registration status of electors. So this is to make sure that the Secretary of State is doing everything possible with every partner organization that they have an agreement with to obtain updated voter registration information. So good stuff here. And that's what this is all dealing with here. And feel free to, again, to go back and read the bill if you like. This is number 281. But that's basically what all this is doing, is making sure that the Secretary of State actually uses the available resources to verify the registrations are current. And it looks like there's some reporting requirements here as well. The Secretary of State's website has to post the numbers of how many electors have moved, been brought in, died, et cetera. So that information is all in here. Looks good to me. More reporting. Next, 282. Let's look at this one. Only the Secretary of State, a designated voter registration agency, which means a public entity, not a private entity, or a county, city, or township clerk shall have access to the qualified voter file. That's, I think, looking to address what happened with Rock the Vote being given an API to be able to submit automated voter registrations. They had a program to let you essentially just query the voter file to see whether or not the voter file was verified. I think we had a small concern about this one, a potential thing, which is that the qualified voter file, there are certain elements of it that are not accessible to the public. For example, I can't FOIA the signatures of all the voters in the QVF. But apart from that, the QVF is public record. Campaigns use that all the time. Consultants use it. If you looked at the beginning of the presentation, we saw what some of the tools available at rescuemichigan.com include. And some of that, a lot of it comes from public records, including vote history, including which party's presidential primary the voter voted in, information like that. So we want to make clear that this should not be seen as a workaround over FOIA. What this is intending to really do is to make sure that it's not giving private organizations direct access to the qualified voter file. And by the way, to be clear, from my understanding of the contract the SOS had with Rock the Vote, they weren't actually submitting registrations directly into the QVF. They all had to be approved by the SOS, but their API was enabling them to see in real time whether or not someone was registered, and if not, to submit electronic voter registrations, which would then still have to go through the SOS. But anyway, that's what that bill does. So I want to double check this language isn't too broad in prohibiting FOIA, but other than that, insofar as it's restricting private entities from getting direct access to the voter file for their own efforts, that looks good. Let's go back, look at the next one. 283. This one, what are we doing here? This one I think was, this is extending some policies that were only to be applied in the November 2020 election. So you see here, it says not later than March 1st, 2021. It adds, and not later than March 1st of every 2 years thereafter, otherwise it would have ended after March 1st. Here we've got up above, taking out for the November 3rd general election only and making it apply on an ongoing basis. What we have here looks like this relates to the ballot absentee voter envelope containers. What is going on here? My default speaker has changed. Can you guys hear me okay? Did I get lost here? What's going on?
No, we can hear you.
Okay. I just saw the picture of me on the screen disappeared, and then I got a pop-up saying my microphone was changed. So I still sound okay? Okay, I'll assume so.
Yeah, and nor is it like the Liberty commercial. You didn't change into a emu or anything like that either.
Okay, good. All right. So anyway, so what they're doing is extending provisions for absentee ballot envelope containers, which are clearly something we want to keep going because, as we'd said in looking through our proposal, we certainly do want to make sure that absentee ballots are handled securely, and that involves keeping them in secure containers. So good stuff here. This is all extending what the existing policy was as it was applied to the 2020 election. So you can read through that bill, and what it's basically doing in this language is just making what was a temporary bill into a permanent one. All right, next up, Senate Bill 284. And this is a report to the legislature detailing each contract the Secretary of State has entered into with an entity for an election-related activity or service, including drop boxes, tabulators. So this is a transparency bill. Looks like everything here is, there's another thing here. This is relating to the private funding of public elections. Shall not accept from an individual entity directly or indirectly a gift of money or other consideration. The language here looks different from ours, although it seems to be doing a similar thing. So again, might be an either or both aspect of it. So take a look at that. Let me know what language you prefer if you think it should have both, because ours was written differently, but I think to do the same thing.
So just one other question that I have.
Sure.
So all of these that you're going through now that are by the legislators, these all have to go through the process and they have to go in front of the governor. Whereas the ones that you're proposing, you're going to go for a citizen's vote and try to get 500,000 to avoid it having to go to the governor's desk.
Well, what I think likely will occur is the legislature is going to take this to some degree through the process, but knowing in advance that a number of these elements will not be signed by the governor, they will pursue a citizen-initiated law. That's what we Our hearing is the likely plan is that they're going to discuss these legislative items individually. But the thing to keep in mind, remember at the beginning I had said a citizen-initiated law can only amend one law. Almost everything they do is amending one law. So all of these things could be rolled into one proposal.
Yeah.
So it could be ours, it could be theirs. It would be a problem if there was both. So what we want to do is look at what things that they're doing, look at the things that we're doing, see where they're different, see where we can find common ground and where we can make literally the best proposal we can that's going to get the most people fired up. Because at the end of the day, number one, a citizen-initiated law, we really do want it to be actually passed by the legislature once we get the signature.
Right.
If we go too far into territory that they don't want to get into and the legislature does not pass the bill, then it goes to the ballot to be approved by voters. And that would mean you would need to get the public to support, the majority of the public to support that. And, you know, the next election, we're going to have candidates for every seat in the state house, every seat in the state senate, every seat in Congress except the U.S. Senate, because we don't have a Senate race coming up, governor, attorney general, secretary of state. I don't want to see all of our activist resources being diverted from all those important campaigns into also persuading people to pass an item on the ballot. So that is not a preferred route. What we want to do is have a bill that we can collect the signatures for, get it passed. So what this is all about right now is getting together, looking at their plan, looking at our plan, seeing how we can make them the best plan possible, because that's what the goal is, to get everybody on the same page. So anyway, all right, so that being said, did I look at this bill yet? Yes, I did. That was the one about gifts, and there was some reporting in there. So let's move on to the next. 285. What this bill does is, this is my favorite bill in the whole package. This is ID for absentee voters. This is the language I think is identical to the language in our bill too. Same thing if they don't have if they sign an affidavit because they don't have ID, the ballot's provisional. So this is one of the best bills in the whole package. It's almost identical, and it might even be identical in form to that element of our proposal. So great stuff all around, top notch. Great minds think alike. Love it. So excellent, excellent, excellent bill right there. Senate Bill 286. Let's see, what do we have here? More about drop boxes. What does this one do? Oh yeah, this one says you have to close the drop boxes at 5 p.m. on election day. Sure, common sense, I guess. Like I said, I'd prefer we just did away with the dang things altogether. But they have them just saying they have to be shut down at 5 o'clock on election day. So that's what that bill does. Let's move along here. Senate Bill 287. This one's kind of cool. We didn't think of this. Prohibiting townships from providing prepaid postage for absentee ballot return envelopes. Simple taxpayer protection, if you ask me. You know, if you're having the government subsidize absentee ballot return envelopes, which elections cost money, we get that, they always do. But at the same time, is this a cost really where that 50 cents for a ballot to be returned is necessary? And besides that, if you have absentee ballot applications going out en masse, as they were in the last election, and people are applying for absentee ballots but not returning them, you've just wasted the postage. So money gets wasted that way. So good thing, fiscally responsible. Not the top of my list of most important priorities, but it's not a bad bill. So there was that. Senate Bill 280, so subsections 3 and 4. Okay, this is relating to audits. Not less than 5 days before the date of an election audit, the appropriate city or township board of commissioners must appoint election inspectors. Okay, so election inspectors are appointed for audits. Okay, and they have to choose them from 2. Let's see here now. I wonder, the appropriate city or township board of election commissioners where each precinct to be audited is located must appoint 2 election inspectors, 1 from each major political party. This is where I'd probably amend it the same way that our proposal helps ensure that the poll workers are genuinely members of the respective parties by having the parties submit a list for who would be their first preferences to be election inspectors. Because the fact that Michigan does not have partisan voter registration makes that a workaround. People can just say they're a member of a party, and there's almost never a way that they can be proven not to be. So preferably they would clamp down on that a little bit. But otherwise, good stuff. In addition, the Secretary of State shall provide live video streaming of the election audit in each precinct on the Secretary of State's website. So I like that, transparency. It'd be interesting to see how an election audit is actually conducted. I think the public would like to see that. So very good. And then here the political parties actually do designate the observers. So there is that. So good stuff. I like it. Didn't think of that one. And move on to the next. Senate Bill 289 prohibits federal funding of elections that are not approved by the legislature. Clever. Didn't think of this one. If the state or state agency receives or is eligible to receive federal funds for election-related purposes, they may be received and expended only after satisfying certain conditions placed by the federal government. The federal funds must not be expended except upon appropriation in a budget act. The federal funds described in this subsection are not appropriated in a budget act within 90 days after the state receives the federal funds. The funds are returned to the federal government. And let me be clear here, the federal funds, this must apply to the state legislature, not the federal government. Because if they're receiving money from the feds, they've obviously already authorized the appropriations. So it's saying if the federal government, if the Biden administration wants to drop a great big pile of cash on Michigan for voter registration drives in liberal cities, and I'm sure they'll find a clever way to describe cities such that they benefit the left. They don't just get the money; they have to actually have the money approved by the state legislature. So, smart one. Very, very, very clever. They caught that. I like it. Good bill. And moving on to the next, 290. What do we have here? Now this one, okay, this one we're going to have some discussion about. First of all, they do have some of the things that we had in ours. This one's about requiring challengers to identify themselves and which political party they belong to. I thought they already do this. We've had it on the poll workers, not the poll challengers. But here's the bigger thing. They're removing the ability of nonpartisan organizations, and I quote unquote nonpartisan. The only people that get to be poll challengers or who get to appoint poll challengers are candidates and political parties who have candidates on the ballot. The language that's removed is anything allowing an incorporated organization or organized committee of citizens interested in the adoption or defeat of a ballot question being voted up for or upon at the election, or interested in preserving the purity of the elections and in guarding against the abuse of the elective franchise. I see what they're trying to do here. The concern, I think, is that private political organizations can basically function as a workaround over the limits of poll challengers. So whereas if the law says you can only have 2 Republican poll challengers, 2 Democrat poll challengers, well, 10 different left-wing groups can also have 2 poll challengers. And so therefore you could potentially have more challengers that way. But there's at least a legitimate question about whether or not you want to seal off access for poll challengers to only be members of the 2 major or maybe it's not only major, but it likely would in practice only be the major political parties and candidates. So that's an open question for discussion. I don't have extremely strong feelings one way or the other about it, but well, there it is. What this bill would do is prohibit private entities from appointing poll challengers. Only the parties and the candidates would be able to appoint poll challengers. So that's that one. All right, moving on. Senate Bill 291. This bill does not change the election law. This changes the Code of Criminal Procedure. So in a citizen-initiated law, this one probably wouldn't be a part of it, but it also probably wouldn't matter much because if the citizen-initiated law was to pass, they would just pass this as a bill anyway. It is just striking provision in the sentencing guidelines for things that I think they'll be making no longer crimes. In this case, election law filing certain false statements under section 731.4. And I think I went through that one in the page and examined exactly what this is that we're looking at. So let's see, Senate Bill 291. Yeah, companion to the bill we just looked at, it makes it a 2-year felony for a person to file a poll challenger statement on behalf of an organization that's not authorized to appoint challengers, and for a clerk to knowingly fail to perform the duties required in designating poll challengers. So they're saying we're eliminating the ability of those other than parties and candidates to appoint poll challengers. So we no longer need to have this element in the Code of Criminal Procedure. So doesn't really change much of anything, just a companion bill to the one that we just looked at. So we can just move on from there. 292. Secretary of State shall do all of the following. And what we change here is a comprehensive training curriculum for each political party that seeks to designate election challengers at an election regarding the powers, rights, and duties of election challengers. So the Secretary of State will establish a comprehensive training curriculum for poll challengers. And what we have here is that a political party, and crossing off private organizations, only a political party is going to be doing this. And down here, it says a challenger must not serve as a challenger unless he or she has, within the last 3 years, attended election challenger training as described in section 730A and submitted a signed affidavit attesting to having attended the election challenger training to the political party that conducted the election challenger training. I see here what they're trying to do also. It's the same as what we were doing in our proposal to stop them from just hiring people off of the street to be heavies. Requiring poll challengers to take training. The issue I think we may have with this is that what they're really essentially doing is imposing licensure on poll challengers and imposing the terms of the licensure from the Secretary of State. The Secretary of State will establish a comprehensive training regime curriculum for each of the political parties that designate poll challengers. And, you know, if we're going to do this, it seems to me the thing to do would be to establish the training curriculum right here in the statute. You know, why give the Secretary of State the rulemaking power that we know she's going to write in every way possible to benefit her side and not simply have the training curriculum laid out in the statute itself? That seems to me to be a better way to go about doing that. And then even that notwithstanding, there's still a question of, do we really want the Secretary of State to be licensing essentially the private political organizations, the political parties? So there might be a limited government issue here. And again, you know, giving the Secretary of State that authority could be problematic. I prefer at least the approach that we took, which is to stay in statute. The training must include the rights of poll challengers. They must tell them it's a felony to impede poll challengers. They must tell them that they are required by law to wear their name tags at all times. If anything, I'd beef up what we already have in our proposal and really spell out exactly what a training curriculum should include for poll workers, and maybe also for poll challengers. But I don't know if I'd leave that to the Secretary of State. So, so there's that. So that's that Senate Bill 292. That's one to keep an eye on. 293. This is another one that's changing the election law. This is, I think this one is actually word for word the same as 291. I had to go back and forth a few times to confirm it. This bill is the exact same bill as Senate Bill 291. So I don't know if there was a mistake at the clerk's office or some kind of mix-up or something. This bill is word for word identical to Senate Bill 291. So don't know what happened. Don't know if something else was supposed to be there instead, but that is the case. 294. This bill. Okay, so what this bill is doing, this is relating to the hiring of precinct inspectors, which means poll workers. We talked about how our proposal is going to do that. What this proposal does is makes it so that they are not allowed to appoint more than 2 to 1. As you can see in the existing law right above it, it says right here, the Board of Election Commissioners shall appoint at least 1 election inspector from each major political party and shall appoint an equal number as nearly as possible of election inspectors in each election precinct from each major political party. And they add that this they cannot appoint more than 2 to 1. And at the bottom of the bill, it says, and if somehow they fail to do that, it actually says if they fail to appoint an equal number, they have to submit a report to the Secretary of State explaining what efforts they took to recruit from each major party. So I do like this. The one thing that our proposal addresses that this one does not is the hazard of the fact that people can simply state falsely what political party they belong to. And that was what our proposal was going to remedy by giving the county parties the ability to send a list of who they prefer to be election inspectors that would have to get first preference in hiring. So that's an element I think that needs to be added in that is not in this one, but that's that one. Let's move on. Senate 5. This is relating to trainings. The training of precinct inspectors by either the director of elections of a county, city, or township clerk must include training on precinct inspectors conducting regular balancing checks at least once every hour in each precinct on election day. And to confirm the total number of ballots issued at a precinct matches the total number of ballots tabulated by the precinct tabulator at that precinct. Good. I mean, not bad. I would add more to that. Obviously, what we were talking about earlier was adding in the requirement that they train them on the rights of poll challengers and the criminal penalties they'll face if they impede poll challengers unlawfully. There may be even more things that should be added in as well. So let's do that. Hey, Shane, are you still with us?
Yes.
Hey, I would like to take a quick break for just a moment. In the meantime, you want to look through the questions and just, you're even just open it for discussion, and I will be right back.
Sounds good. I'll try to address any questions that I see over in the chat.
All right.
Like I've, like I was explaining over there, this is, a framework we're developing. We want to have the strongest legislative fix that we can for these many problems that we're facing in terms of our elections and what the legislature has put forward. There's a lot of good in there, but there's a lot of things that could also be problematic. So what we want to do is we want to make sure that we're not just sort of blindly following our lawmakers and blindly following, that they're going to do the right thing, but that we're engaged in the process. We're informed. We are challenging them when they need to be challenged. So that's really what we are trying to do here. We're trying to get the best possible language out there so that we never have to deal with the a Soviet style vote steal that we like what we experienced in 2020. So we're just doing the best we can to make Rescue Michigan the best proposal possible. Some people said, what are the odds of us getting this passed? What are the odds of this going to, obviously it's not going to be signed into law by the governor, but what will we be able to get into a citizens referendum where we're going door to door and we're collecting signatures to get this on the ballot so that it's in effect by next year? And the answer to that is I think that as much as we push back and as all these bills, that the bill packages that has been put forth thus far, one thing that we can push for is for provisions that are in the Rescue Michigan comprehensive reform, making sure that those provisions are added into bills that have already been introduced. That's probably a way where our efforts, there could be sort of a synergy in our efforts, and that's going to be a way that we can get the best proposal forward, and then we can go door to door and collect all the signatures that we need. And I know Adam will be going through briefly what's happening with the what's going on with that database and how you can use it. It's very easy to use. It's very customizable. Has the better, in my opinion, probably the best voting data in the state that any program is using. So, and that can be used to support Rescue Michigan's proposal or the Senate proposal, or any other issue with regards to elections or on anything else. So Ad will be going through that in a minute. I see Beth has a question. Will the legislators listen to what you're saying? They seem to be ignoring their constituents. That's a good question. Obviously, the legislators have not been as responsive as we'd like them to be. Obviously, they could have done more in the immediate aftermath of the election to, subpoena the people who were running the vote steal operation down in Detroit at TCF. They didn't do that. It's almost like that they were happy to sweep it under the rug. One thing that I would say that's a good sign is that they did put forward the Senate bills. They do intend on moving those forward. And there's a lot of good aspects of those bills, but obviously they haven't done enough. And I would not, accept at face value that these Senate bills have, are going to be passed, are, going to be rubber stamped. Don't necessarily accept that these Senate bills are enough. Just make sure that you demand the best possible reforms as possible. I have talked to different lawmakers about this. The ones who wish to actually have the reforms, and what they're basically telling me is that leadership is not wanting to use their full authority to get the word out about this, and obviously as we saw with people like Lee Chatfield and Mike Shirkey. Saying that essentially, and other lawmakers as well, essentially saying that there was no election fraud that determined the outcome and it wasn't that big of a deal. So, yeah, it's a little bit crazy, but someone posted there that in the chat.
Jane, can I comment on that too?
Yeah, go on.
So for one thing, there is going to be a process of dialogue that is just now starting. The reason why we have not already spoken to the legislature about all these provisions is, frankly, we just got our draft proposal done just the beginning of this past week. And clearly, just by the quantity of the legislation that the Senate's put out, they have been working very hard on this themselves. So there will be an ongoing dialogue over what elements of the plan that they've put together that we think need to be added. As we've seen, there's some aspects of this that sound great. There's some aspects that sound not so great. My understanding, and if you'd seen the state GOP put out a news release about the Senate plan the day it came out, they are looking to deploy resources for election reform. And our proposal, frankly, is not to pressure lawmakers into doing things that we think should be added, but to sell them on it and say, if you guys want us to go out and collect 500,000 signatures of voters saying this is what we need to do to fix our elections, give us the best plan we have possible that's going to give people the enthusiasm to go out and do this. So, for example, one of the things that we haven't seen and we're not going to see in the Senate plan was our option to our provision about giving the parties first preference in the hiring of poll workers. And that's an important point because one of the major ways they're allowed to manipulate the election results is controlling the environment and who is staffing the polling places. So it's in their interest to do that. It's in our interest. They might have just not thought of it. Regarding all that happened in the aftermath of the election, we have now new lawmakers in the state house, new leadership in the state house. I think there was a lot of intensity on the lawmakers. Remember, if you saw that story in Time magazine about how the establishment controlled the media narrative of the election from start to finish, which if you read the article, they were actually intensely focused on Michigan. People were being bombarded from every different direction in an extremely frantic manner. We now have the ability, now that the dust has settled, and not in our favor, but at least the dust has settled, to really now take the time to get all this right. And that's what we've been working on for the past couple of months. That's what they've been working on for the past couple of months. So we're not yet at a point where this has to be rushed. If we go to a citizen-initiated law, the process is 6 months of collecting signatures, and then they have to have them approved by, I think, the July before the November 2022 election. So we could start as late as next January. I don't think we want to start that late. We want to get signatures this summer when the weather is nice out and people are going out knocking on doors. But we don't need to put ourselves into a panic just yet about rushing out the door with a citizen-initiated law. It's going to be a process that takes time to get the policy right. It takes time to fundraise. It takes time to build the coalition. and we don't want to put the cart before the horse. This is going to be a major endeavor. And I think it's going to be what we call an opportunity battle, that we're going to be able to grow grassroots organizations and grow the party through this kind of outreach on this kind of legislative advocacy, because all the elements that we're addressing in our proposal, and I think much of what the Senate's addressing in theirs, are things where we can prove things were done improperly. We can prove they were manipulating who was working at the polling places. We can prove they were criminally impeding poll challengers. We can prove that they didn't follow the Administrative Procedures Act when they changed the signature verification standard. So if we have this out in the court of public opinion, I think there's a lot of opportunity for us to advance these issues effectively. So anyway, all that being said, okay, it's almost 8 o'clock already. I was going to try to get this done by 8, and then I still want to answer questions, so we will go late if we need to, but let's just blast through the rest of these as best we can. This bill expands the canvassers boards in large counties. So in Wayne, Oakland, and Macomb County, you'd have an 8-member board. In Genesee, Washtenaw, Kent, those kind of counties, you'd have a 6-member board instead of 4 members. I think the idea here is that the canvassers would be more comfortable in numbers in resisting the mob that came after them in November 2020. So that one does. Good policy, just fine, nothing wrong with it. Senate Bill 297. This one requires at least one member of a political party be present during the entire canvassing of returns. And it also has a provision here that says any assistant of the clerk that the clerk employs must not be hired until approved by the Board of County Canvassers. So it gives the county canvassers the ability to approve or disapprove of the hiring of assistant clerks. So good one there. Didn't think of that. I like it. Let's move on to the next one. Senate Bill 298. This one, what are we doing here? This is extending the length of canvassing time from 2 weeks to 3. So where before they would have to be done no later than 14 days, now we're giving them 21 days. So they have more time to canvass, more time to find fact. Good stuff. Didn't think of that one. Good job, Senate. Senate Bill 299. This one, let's see here. I think that's all. Yeah, all this one does is say that the Board of Election Inspectors has to deliver the envelope to the clerk of the township not later than 12 noon on the day following the election. Good. Not sure there's an enforcement mechanism here. Doesn't seem to be. So not sure what the remedy would be if they didn't do that, but no reason why that shouldn't be in the law. So seems fine. Nothing wrong with that one. And now we come to Senate Bill 300, and we got to talk about this one, guys. I don't know how this one got in here. And by the way, if we go back, let's go back for a second. All these Senate bills, if we look through them, look at the sponsors, you see recurring names. Lana Tice, you see Kevin Daly, Jim Thomas, Kurt Vanderwall, Ken Horn, Kim Lasada, Dale Zorn. You see kind of the same names on them here. Ed McBroom's on that one. So a lot of similar names. These are probably members of the Elections Committee. Rick Outman's on this one. You see all these sponsors, and the names are kind of repeating. Senate Bill 300 seems to have a couple of fewer sponsors than the others. Doesn't have Ruth Johnson's name on it. Doesn't have Lana Tice's name on it. Yeah, and there may be a reason for that, because let's look at what this bill does. This is kind of a doozy. On the day of an election, the polls must be opened at 7 and must be closed until 8 o'clock, crossing off and no longer. What's going on here? Well, on here, for early voting under Section 720A, which Section 720A is here, and it's a brand new section, the polls must be open from 8 a.m. till 5 p.m. on the second Saturday before Election Day. The clerk will provide notice to the electors, the voters, as provided in the section, time and place in which early voting will be held. Before early voting begins, the clerk will post notice. And every city and township must have at least one polling place for an early vote on the second Saturday before Election Day, 10 days before the election. All the trappings of an election, inspectors, challengers, poll books, notices, security systems, ballot security stuff, spoiled ballots, the poll book. This is a second election day, folks. This is a second election day. And already they're anticipating there's going to be issues with this because they have to define felonies for what happens if a poll worker leaks what the results are of the pre-election election that Saturday.
When did more than one vote
pretty
date
problematic.
happen?
I have no idea whose idea this was. This looks like the exact opposite of what we would want to have.
Right.
And the thing that we should emphasize is every time you make an election more complicated, you make it harder for the average Joe that's running for office that doesn't have a political machine supporting him. And people like John Riley, who went from being a guy that owns a sprinkler repair business to a lawmaker, you'll see fewer and fewer of guys like that if you make elections more and more and more cumbersome. Because the absentee chase, election day operations, all this stuff is time, money, logistics, personnel for a campaign, and they're hard. And they're adding to the complexity. So I have no idea why this is here. I'd love to find out. Love to know whose idea this really was. But this bill, I mean, I had to read it twice just to confirm I wasn't seeing things. This is creating an early voting election day, in-person voting at the polls with an open poll in at least every single city and township, at least one location. Don't know how this got in here, but hope they do something with it, because here's the issue. We've been talking about all these bills in the context of a citizen-initiated law, and the legislature may hold all these bills until signatures are collected on the language that matches what a bill does. But if the idea is, let's pass all these bills, see which ones the governor signs, and maybe we'll use a citizen-initiated law to overcome the veto on all the others. Well, the problem here is she might just sign this one bill into law and veto all the others. So that's a place we don't want to go. So that bill 300, I'm flagging that one. Something's not right there. Anyway, it's almost 8 o'clock now, so we're going to go quickly. Senate Bill 301, Men's Code of Criminal Procedure. Again, this is for disclosing the results of the election on the early voting. So this is a companion bill to that one we just looked at. And again, they're already anticipating there's going to be problems. So you've got tampering with the ballot container in early voting and disclosing a result or characterizing how a ballot was voted before the close of polls on election day. Those being new felonies they need to make. So, I mean, the security hazards are just that apparent. Senate Bill 302, we're getting near the ends, folks, so we're almost done. Senate Bill 302, this bill would require a statement from the elector on an application that does not claim voting residence or the right to vote in another state or territory. Don't know how common a problem that actually is. Nothing wrong with that being corrected. But, you know, part of the other issue is, though, there's a whole section on electronic voter registration. And a lot of the usual safeguards like address verification by looking at a utility bill are not in there at all. So if anything, I wish they would tighten up that law or that element of the law, and maybe we need to look at that too. Senate Bill 303. What are we doing here? We are crossing out. Oh, this is a cool one. I like this. This is a great one. We're back to the good stuff again. This bill makes it so that if a voter does not have ID, rather than sign an affidavit, they get a provisional ballot. That's much better. A provisional ballot is not counted unless after the election, the voter goes back and provides verification of his or her address. It puts the burden on the voter to prove they actually are who they are, not the burden on the poll challenger to challenge the ballot, to give him a challenge ballot and have it still be counted at the polling place on election day with no signature comparison. So great stuff. Good stuff to the end of this one. I like it. Awesome. Glad to be back in the right side of things again here.
Can we go back? I have one question about
sure.
invalid addresses. So yes. Is that commonly how, like, we have tons of migrant, well, you know, transient people, and they use addresses that they really don't live there. And I mean, what do you do in that scenario?
Like if someone doesn't live in a home?
like if the address is completely invalid, there's no home there. It's a field.
Well, you're not supposed to register to vote at an invalid address.
Right. Well, obviously, yeah.
And when you register to vote in person, they require you to show, like when you get a driver's license, you're supposed to present proof of citizenship and proof of residence. But the electronic system doesn't really have that, so that is a potential issue. All right, I'm gonna go fast, guys. We're past 8 o'clock. It's already been 2 hours. You all been on for a long time, and I know you guys have questions, so we're gonna stay on. But let's just finish these off. We got, I think, 8 more bills to go. Senate Bill 304. What does this one do? Oh, this is same as the last one about requiring provisional ballots if they use an affidavit instead of ID. Good stuff again. Those could have probably both been the same bill. I don't know why they broke them into two, but so be it. This one, okay, this is a funny one. I like this one. Notwithstanding any provision of law to the contrary, the name or likeness of an elected or appointed official must not appear on or be used in any communication that is paid for with public money and involves an election-related activity. Election-related activity meaning registering to vote, voting, applying for an absent voter ballot. Name and likeness does not include office, title, address, or telephone number as long as that contact information does not include the name or likeness of an elected or appointed official. Here's what I find funny about this. What the bill's trying to do here is to prevent public officials from putting out helpful information with their name and likeness on it that's paid for at taxpayer expense and telling them how to vote or how to register to vote, rather. Essentially using their office resources to be used for voter registration drives, that kind of thing. Funny thing is how this bill is drafted, though. You could say this is so broad that, for example, a lawmaker wouldn't even be able to respond to a constituent asking them how to register to vote, because it just says, notwithstanding any provision of the law to the contrary, the name or likeness, the name of an elected official must not appear or be used in any communication that is paid for with public money. That includes their email addresses. That includes their snail mail. That includes their office allotments. So they might want to tighten up the language of the bill a little bit, because I know what they're trying to do here. But it might actually go so far as to prevent public officials, all public officials, including lawmakers themselves, from communicating some basic information to their constituents. So again, good intention. Might want to tighten up the language a little bit on that one. Senate Bill 306. Not later than 45 days after each November election, the Secretary of State must prepare a report for the legislature on the course of instruction as required under Section 31, Section 1.1. That was probably one of those previous bills we looked at. Oh, this is the one. This is the one about shaming clerks that don't stay current on their training. That's what that is. So that's how the Mackinac Center described it. They said they're shaming clerks that are behind on their training. So clerks have certain education and continuing education requirements, and this bill says the Secretary of State has to post on her website who hasn't taken their training, who hasn't taken their continuing education, so that their constituents can beat them up at home for having not done that. So that's funny. I don't know. I think it's a talking point bill, basically, because it came out that a lot of clerks are behind on their training and hadn't taken them. So funny. I mean, I like it, but not a huge policy change. This is a cool one. If a ballot proposal appears on a ballot provided to an elector, the full text of the ballot proposal must be provided to that elector. That means anytime something is on the ballot, the full text of the entire proposal has to be given to every single voter. And the effect of that will be to lead a lot more voters to want to vote no on things, because voters tend to vote no on things they don't understand. And when they don't get just a 100-word summary, they get the entire text of the proposal. They're going to see all kinds of things and wonder what they mean. And not always, but for the most part, ballot proposals are tax increases. So I like this one. Very clever, whoever thought of it. I see Tice is the top name on the list there. Great work, Senator Tice, if that was her idea in the first place. If not, thank the policy staffer. That was a good one. Senate Bill 308. What are we doing here? We are establishing and requiring signature verification training for all county, city, and township clerks that comply with the rules promulgated by the Secretary of State under subsection 3 for an objective signature verification process. So this is their bill imposing signature checks and requiring a uniform signature verification policy. word for word different from ours, so I'm not sure what exactly the difference is. I see here it does say it must not include a presumption regarding the validity of any signature that is to be verified. Excellent, excellent work. Why its language is slightly different from ours, I'm not sure. Might be an either or and both kind of situation, but great work, important bill, rock solid part of the package. Glad it's in it. Senate Bill 309. What are we doing here? This is the one that's codifying the rights of poll challengers. These are rights they actually already have under law, but apparently the Secretary of State failed to comprehend it a little bit. So we're clarifying by spelling out in statute, each stat challenger has the right to stand or sit behind the processing table, observing the election process at a reasonable distance meaning they can actually read it. So this is all good stuff. Although this is all currently still the law of the land, it's just that it's being spelled out, clarified for the slow, i.e. the Secretary of State, although the Secretary of State's not slow. What she was doing was intentional and she knows it. But here's a new bit. This is different. Allowing recording devices in polling places as long as the usage of them does not hinder or impede an elector's right to vote or right to vote in a secret ballot. Good stuff. Transparency, documenting evidence. Politically, it might be tough. The left's going to go crazy over this one. But I salute them for having the courage to at least put it out there. So great policy. Politically, be a tough road, but we hope they pursue it. Senate Bill 310. What do we have? Please mute yourself before you cough very loudly or sneeze or whatever that was. Thank you. All right, Senate Bill 310. What are we doing in this one? We're almost done, guys. This is the second to last one. Unless a voter requests the Secretary of State provide an application, the Secretary of State is prohibited from sending or providing an absentee voter ballot application to the elector. Great stuff. Similar to what we do, although our proposal also covers third parties not being allowed to send out absentee voter applications, and clerks only accepting the ones that are issued by their offices or from the federal postcard. So I say do that and do what we did, belt and suspenders, lock them down. So good solid bill here. And then finally, Senate Bill 311. And unfortunately, we don't end on a very high note. This one is to require the ability for the clerks to accept electronically submitted ballots from overseas uniformed voters. Issue is when you create that process, you're opening that door, and it's going to be, once they say we've already got the process for accepting absentee ballots electronically, it makes it easier for them to accept all ballots electronically. And that threatens the paper trail, which is one of the most important checks on vote fraud, is that there is a paper trail. We do have paper ballots. But in this case, they're creating a process where before an election, they may electronically return a voted ballot to the appropriate clerk to be counted on the policies and procedures established in the bill. So in and of itself wouldn't be a huge issue, but they're creating a system where they would be able to accept electronic ballots. So I think this one is probably a cause for concern. Not a huge cause for alarm, but something we probably don't want to see. And some people are going to be real concerned about this. So, and there's all this language in here about that. The Secretary of State's going to have we're giving the Secretary of State more power to make rules. Whenever it says the Secretary of State shall promulgate rules, you're giving Jocelyn Benson the reins to decide how it's going to be set up. So that's it, guys. That is the Senate proposal. We were going to look at the House plan too, but it's already after 8. It's been 2 hours. These plans have already passed the House. I'll tell you what, I will do a blog entry maybe tomorrow where we go through these, but we've been on a very long call already. It's been more than 2 hours. We have gone through hundreds of pages of legislation. So thank you all for bearing with us. I know that was a lot to go through. We looked at 39 bills in the Senate, and we looked at 177-page bill that we wrote. And there are some things in our own bill that we think we might want to even expand upon. I mentioned several of the things that the Senate came up with that we didn't, that we might want to add in. And I think we looked at a lot of great things in the Senate proposal and a few not so great things. So the hope is that as discussions are ongoing, we continue the development of these policies, and we encourage people to submit their comments on our website to us, because we're going to be redrafting our proposal too. And we'll be starting to reach out in the next week to the lawmakers and relevant people in the House and Senate about these recommendations. So we have gone through a lot. And at this point, we're going to open up to questions. And as I've said, we've been going a long time, so I'm sure you guys have plenty. So with that, we will open up the floor and we will go from there. Feel free to unmute yourself and ask your questions. Hey, Shane, are people able to unmute themselves?
Should be.
Okay, I'm going to look in the chat just to see. We can. Let's see here. Okay.
Okay, we got Steve. I think Steve wants to ask a question. Steve, unmute yourself.
I don't hear Steve. I see a question from Gary. What is the solution for migrant voting? Migrants aren't eligible to vote. They aren't eligible to register to vote. So the solution to them voting is the same as every other fraud protection.
Margaret has her hand raised. So Margaret, if you're available, just speak up and you can ask the question.
Okay, thank you. My issue with a lot of this has been on the enforcement side. And so I have been critical of the Michigan legislature and its lack of enforcement, both from elected officials and from just going out and doing what I think that they probably needed to do early on. It's not like we didn't see the warning flags. It's not like we didn't know what was going on. We stood back and we allowed this train to sort of roll through the station. One of my suggestions, as I have been speaking with other attorneys, and I'm an attorney myself, is we would like to see in these new election laws an ability for private causes of action so that attorneys like myself could represent a poll watcher in that goes to a poll and signs an affidavit, says I was denied my right. I was not able to appropriately see what was going on and it violated state statute. I would like to go into court because the legislature is useless, quite frankly. I would like to go into court and enforce these election laws myself. So if I have 5 or 6 people that want to line up, I can go into court and allege that there was a violation here and the statute can have liquidated damages already in it. So you don't even have to get to the issue of damages. It's $1,000 or $1,500 per violation, and it is against the governmental entity in which the violation occurred. So if it happens in Detroit, it goes against the city of Detroit or the county in which it occurred. So there are many lawyers like myself that would like to see this private cause of action, private enforcement get into the election changes that people are contemplating. So what are your thoughts?
Absolutely. I would encourage you very strongly to reach out to your colleagues and prepare some recommended language for going about. That's one issue that neither of these packages addressed at all, is standing. And in fact, on our election reform page, at the very bottom, that was the page that had those blue and red tabs that said, this is a problem, this is our solution. At the very bottom, under further study is needed, I made the point that the courts are systematically not hearing cases. And the excuse is, it's unripe in the spring, it's no standing in the summer, it's latches in the fall, and it's mootness in winter. So they continue to find ways to avoid actually taking on these lawsuits. So I think there's a lot of ways that we might be able to amend the policy to establish standing and so on and so forth. So if you have suggestions for that, we would love to hear them. Absolutely.
Sure, because you could put a statute of limitations in it. If you don't bring your alleged violation of the law within a year, then you have a statute of limitations on it. And I think you can make it clear that the courts have jurisdiction and that any allegation is to be taken up. I'm just telling you, the frustration out there in the grassroots against the legislature and lack of enforcement is huge. I hope people are reading the tea leaves because it's huge. huge.
Yeah, I think the U.S. Supreme Court did our country a terrible disservice when they refused to hear that case that the state of Texas and 19 other states brought. And frankly, that had as much as anything else to do with what caused what happened at the Capitol on January 6th, that the public believes they have no remedy, not in the courts, not in the legislatures. That's a real problem. So like I said, by all means, send us your recommendations for additional language. I think there does need to be some elements that are lacking that address standing and lawsuits and other remedies. Laura, you have your hand raised. Do you have a question?
Yeah, and what about penalties of officials like Benson, who obviously goes against the election laws, and she removes the signature verification, and she's found guilty of it. How can she keep her position? How can she not have penalties?
It's the system that we have. There's no remedy of removal from office other than by impeachment, and it's not a criminal penalty to have a policy that's found to be invalid. And between us, we all know that this was done in bad faith and intentionally on her part. But can you prove that? And it's hard to say. I mean, she could argue, well, signatures change over time, and it's really difficult to have a uniform signature policy, although that's not true. The financial industry has one. But no, I mean, we have to do the best we can to change the statute to make it so that the conditions that we had in the past election can be averted. And that means being able to document evidence, being able to establish standing, being able to have a proper procedure for hiring poll workers. And as we just looked at, I mean, we just looked at 39 bills plus another 77-page recommendation. There's a lot to it, and there's a lot more that we might have not even thought of yet. So it is tricky, and it really is. And frankly, I think the biggest thing that we need in the upcoming election cycle is candidates who are willing to stand up and say that these Democrats have been acting in bad faith all along. And we don't hear that from enough lawmakers. That when the governor locked down our state and then proceeds herself to go out and participate in a Black Lives Matter march, that proves she was acting in bad faith. And that's true of the Attorney General, that's true of the Secretary of State, and that's true of a lot of others. Frankly, every single member of Congress that voted for impeaching the president on plainly frivolous grounds was acting in bad faith and damaging the constitutional system as we know it. But it is what it is. And frankly, maybe this is a good part to segue to talk about the Rescue Michigan Coalition and what we're looking to do, because it's not just about reforming Michigan's election law. It's about building an effective grassroots movement. And we know we're not the only organization out there looking to do that same thing. Everybody wants to be the numero uno where everybody is organizing and mobilizing at. All I can tell you is that what we've done, other than putting together this proposal, is building a website where we give every single member the ability to access sophisticated voter files and a system to put them into usage. So if other groups want to use that, take advantage of it, by all means, they're welcome to. But all the things that we're looking to do, whether it's reopening our state, fixing the election law, it's about making what we call an opportunity battle, that making the fight grows our organization, grows our movement, improves our political advantage. That's how Democrats operate. They understand that logic. In fact, there's a great book, Confrontational Politics by Bill Richardson, that talks about exactly how the left doesn't take on issues that don't improve its organizational power. The right has the problem of looking at every issue in isolation, and once we win, we go home. We don't build upon things from one cause to the next. In my view, we have a hard road in front of us on retaking our state in 2022. We have House races, Senate races, congressional races, governor, attorney general, secretary of state. That's going to take an enormous grassroots movement. I think we've seen some motion from the party now with the new chairman that they are interested in pursuing the same kind of thing, and that's very healthy. I think we need to have a larger, more sophisticated grassroots, and that's going to benefit all of the efforts to come. So
And Adam, I'd like to interject real quick. Yeah, we're going to be expanding this very rapidly. We're thinking of doing some sort of grassroots stakeholder conference call where we can bring in different groups and discuss what can be done. We're going to be doing, weekly strategy sessions so everyone is engaged and informed. And we'll probably be doing our next one just on the Rescue Michigan database and rolling through all the different features that it has at great length. But there are some people who have questions. I believe. Have you addressed Evelyn Archer yet?
I have not. Evelyn, are you there? Evelyn, you're muted. You got to unmute yourself.
Sorry about that.
Yeah, it's actually a question from Ron, my husband. Thanks for all you do, Adam.
Hey, you too, Adam.
This is a straightforward question. Evelyn and I are both under the impression that Benson used an earlier database, not the updated one that was left to her when she came into office. She used a dirty database to send out all those applications and all those ballot applications for absentee. Do you know whether that's true or not, or do we?
I'm not sure about that, but I do know that a lot of private entities were also sending out absentee ballot applications, and their lists may not have been accurate. And that's one of the things that our proposal addresses, and this was not in the Senate's plan, to say that only the government can issue absentee ballot applications and only clerks are going to accept them.
Yeah.
But regarding the voter rolls too, yeah, there's no question. In fact, a gentleman, I think he's in Northville, put together a graph of voter registrations in Michigan, and you see a regular cycle of them increasing in October, and then they drop down again. And then he goes to the 2020 election, and hundreds of thousands of new voters were registered. Let me see if I can find that. I think I've got it on my computer here somewhere. It was a remarkable statistic, and I unfortunately I'm not sure how to actually use it. Hold on, I'm just looking through my screen here to see if I've got it someplace. Well, it's not coming right up, but yeah, there's no question the voter registration rolls were inflated extraordinarily in the run up to the 2020 election. And then, of course, only a month or two later, the Secretary of State says she's cleaning up her voter rolls now the election is over. Now she's removing all these voters.
They were clean before she took over. All she had to do was use to cleanse the ones that had already been cleansed, and it would have been a far better solution than what.
Well, yeah, although data decays at a pretty amazing rate. I mean, any given year, about 20% of your data goes bad. So it's an ongoing process to keep voter rolls updated, and that's just something that that every Secretary of State needs to be doing. And ours this time was more concerned about sweeping in as many possible names into the rolls as that she possibly could. So
it should be a required part of the position. Maybe part of the election, rules that you're talking about. Maybe that's something that could be included, that's required of the Secretary of State. Two very brief comments. Thank you so much for all you do. You are an amazing person. God bless you for all the time and effort that you put into what you do to keep us aware of what's happening and give us direction for the efforts that we choose to put out. And lastly, two more. The person who has the legal background, 100% behind your thoughts and idea. I think that's an outstanding way to approach it from a legal standpoint. And lastly, we're heavily involved in grassroots efforts. And I can't thank you enough for giving us direction. And we have the same situation where we have people all over our community that are looking to what can we do? They're looking for direction. So when you help us, we help another 150 people or 180 people. And if we pull together and continue to grow with this movement, I think that there's no way that we can't stop this atrocity that has taken place in the last election. That's all I have to say. Thanks very much, Adam.
Thank you, Ron. First of all, thank you so much for the kind words. And for those of you who don't know me, me and Ron have been involved in politics in the Oxford area for the last couple of years because I worked for Representative Riley. And by the way, folks, Ron and Evelyn also have one of the best township-based grassroots organizations that we're trying to replicate around the state everywhere. Some people are talking about getting groups going in every county in Michigan. I like to see groups going in every city and every township, because there are enormous numbers of Trump supporters and people out there who are furious with the state of politics in America today. And they are your neighbors. They're waiting for someone to knock on their door and engage them. And what Ron and Evelyn have done in Oxford, they now are having like 70 people show up every single week at their local grassroots meetings. And that's a township of 7 precincts. So do the math on that. If you live in a city of 40 precincts and you have nothing going on locally, there's a lot of people out there that are waiting for someone to knock, for you to knock on their door. So we'll talk more about that in greater depth probably next week, going over some of the organizational mission of the Rescue Michigan Coalition. In the meantime, by all means, check it out on our website. There's a lot to read through there. So again, thanks for the kind words, Ron and Evelyn, and let's move on to another question. Bob, your hand's been up. Do you want to ask the next one?
Thanks, Adam. I just wanted to mention that I think this is a great start for election integrity. We've been looking for some direction in that regard, and this fit my bill really well. I also wanted to know, did you have any thoughts about contacting or getting like Michigan Townships Association, clerks associations throughout the state on board with some of your proposals? Because they're going to definitely look at this from a cost standpoint and a personnel standpoint of what's this going to take, you know, for me as a local county or township clerk to comply with all these extra requirements.
Yeah, I will fully anticipate they will be in opposition for exactly that reason. They don't want to do stuff. They don't want to have more work on their plate. They don't want to have more costs. And unfortunately, elections do cost money, and you know, there'll have to be appropriations for it. But elections are also important. You know, billions and billions of dollars are determined by the results of an election and where they go. So, you know, happy to talk to them. But as I say, I've worked in Lansing. I know the MTA, and I think they're not going to like this. And unfortunately, they're not the only stakeholders out there. The real stakeholders in this are the voters, and that's where the grassroots leadership is going to be so important. So
I still think there's a lot of clerks out there that would welcome this.
There may be clerks, but you know, the Townships Association doesn't represent every single township at all times. I mean, I worked in the legislature, and we'd have conflicts where the Townships Association would oppose legislation that our local townships were begging us to pass. So, you know, and of course, you know, the Chamber of Commerce does not speak for every business owner. That's for dang sure. So, unfortunately, the institutional forces, you know, tend to go with either the biggest entities. For example, Chamber of Commerce, biggest entity is big business and government, not so much the locals. So yeah, there may be clerks that really support this stuff. I hope there are. Hope they speak out. My hope would be that any clerk would be interested in winning the next election and would want to campaign on this kind of stuff. So, but we'll see. But like I said, my experience with government entities is that their lobbyists are not in favor of more work and not in favor of more transparency and not in favor of changing anything. Usually, the greatest force in politics is the status quo, because anything that's controversial, no one wants to do. So that's where the force comes from on our end. That's where the grassroots has to be mobilizing upon the politicians that this is stuff that we got to get done.
It might behoove us to reach out to the elected officials and see if they can't look for some funding sources to help the townships comply with these extra 39 bills that they're proposing.
Oh yeah, well, there would be funding in the budget. There has to be. Under the Headley Amendment, there has to be. So that would come. So all right, moving on to William Hartman. You have a question, sir.
Yeah, I'm on the Wayne County Board of Canvassers and took all the heat. So I do like a lot of the provisions that you have on the in Rescue Michigan, the Senate and the House, especially with increased transparency. I think that's something that's really, really needed. I would like to see more verbiage concerning the chain of custody, especially how ballots are transferred. They should be by, say, law enforcement, not just the guy from the DPW, the types of containers that they should be transported in. That would be verbiage I did not see written into bylaws as of this time. Your input, please.
Sure. Yeah. Well, as I say, I think the best thing with the ballot containers, the absentee voter drop boxes, is just do away with them. But yeah, we are open to recommendations. If you have suggestions, please drop us a line. Use the contact form on our website. Everything that we looked over tonight is all listed on there. So by all means, and I know we've gone through a lot, so that's why we're doing this, is that we want everybody's feedback. We want recommendations. We want to see what more we can do, because we're only going to get one shot at this, folks. So that's why we're doing our due diligence. So
thank you.
Thank you, sir, and thank you for your service. I know you had a rough couple of weeks there, let's just say. So, all right.
Yeah, you could say that.
Yeah. All right. Kevin Hurley, your hand is raised. Did you have a question, Kevin?
Adam, thank you again for including me in this. I got the email earlier and was very pleasant to jump on this. So a couple things. I've got some points here I want to touch on, and then a couple of questions.
Sure.
So one of the big issues I see with regards to public officials is there's really no personal liability to anything they do. A public official can pass a retirement provision for their local municipal employees, which doesn't bear any fruit until 20 or 30 years down the road. By that point in time, they're long gone. So there's no personal repercussions to this. So I think we need to really address the personal liability for the officials for any violations. I think we need to pierce the municipal shield of that. So that's number one. I think that the video capability, I think, bears a lot of merit. I think we also need to have the allowance for remote viewing of the canvas by both parties, because you'll never really know who's monitoring what's going on remotely. So I think that might make some consideration to have added into there. The list of candidates who or current legislators who are in alignment with this, we need to be aware of, so we can support them and have a conversation with them so that they understand that we're in alignment with them. So I think that needs to be something, maybe you add that as a component of the website going forward.
Sure.
And then as a personal note, I'm a current precinct delegate here in Commerce Township, and I was a poll challenger in the city of Detroit in 2000 during the 2000 presidential election. And I didn't know what I was doing.
Did you mean 2020?
No, 2000 was the Bush campaign.
Oh, okay.
So it was very enlightening to me. It was my first exposure to that type of an event. We went through a very hurried training program, and to be perfectly frank with you, I didn't have near the capability that I needed to go into that type of situation. So I think we need to have a very robust program to bring up to speed those who are going to be poll challengers, because that's a very critical component to this whole process. The one thing that I do recall very vividly is I indicated there was an individual who showed up at the poll, wasn't on the register. They said, okay, well, you can do the provisional ballot. Well, he completed the provisional ballot, and they still ran it through, even though I told them that I was challenging the ballot. So what is the provision? What is the repercussions if a precinct processes a ballot which should have been challenged? You know, those types of questions I think need to be addressed.
Right. Yeah. Or, I mean, ordinarily the way that should be addressed is, number one, the challenger documents the incident, puts it in the poll book, files a police report, and, well, maybe not files a police report, because I'm trying to think, would that be a felony under the state law? Well, that's a good question.
Yeah, again,
I mean, potentially you could file, if you file the complaint, you know, potentially a court would consider it. The problem is, what they'll often say is, well, that's one ballot. We can't prove that happened a million other ballots, so it probably wouldn't affect the result of the election anyway. Right. So that's the kind of thing where we'd appreciate input from attorneys on what we can do to address remedies for procedures being violated. And that's one of the biggest things. And when I did my poll worker training in the city of Detroit, they gave us no instructions whatsoever on the rights of poll challengers to have their challenges documented. In fact, it basically said, if you don't agree with the challenger, you just ignore them. And that's completely not proper. So,
that's where we were at 20 years ago.
Yeah. It's amazing. Well, it's been a very educational experience for for everybody that was involved in that last election. And I hope at least part of that it will translate into better training and preparation for the next one. You know, one thing about, I've been involved in GOP politics for about 13 years now. And the first time I went to a Republican convention, we were in the insurgent minority of non-establishment people. I was a Ron Paul supporter, and the establishment was all supporting Mitt Romney. So as you might imagine, we got rolled over at the conventions. And I tell you, I've told every new volunteer, new activist that's gotten involved in the years since, always go to your county convention, because even if you don't have a major fight to make, you will learn something every time. Because if you've never been to a convention before, you don't know the process, you don't know the procedures, you don't know what to expect and what and how to fight back when when the time comes. And it's the same thing with the elections. The very few people have experience with elections, and I've learned a lot of things every time. I learned a lot as a poll worker that I didn't know before. And we had someone in the city of Detroit who voted for her husband, and I say, I don't think she can do that. Like, no, that's fine, that's fine. Yeah, you're allowed to do that if you're an immediate family member. That was not true at all. And so we had the incident documented in the poll book. But anyway, Shane, I just saw pop back on, and he just sent me some text. So, oh, okay, never mind. Well, tell you what, folks, that was the last hand we had raised, and it has been a long, productive conversation that we've had. So I don't want to just cut it short, but at the same time, it's also been a very long event, and we've gone through a whole lot. But let me just invite everybody to go to rescuemichigan.com. You can review the bills in more depth at the site. You can read through every single one. They're all linked there. You can also sign up at rescuemichigan.com. We'd encourage you to take a look at what we have available on the site. If you want to obtain your precinct voter file, that is probably the most powerful tool for getting a grassroots organization going right in your own neighborhood. And I'm telling you, folks, there are people out there. If you've never knocked on doors, the power of door knocking is incredible. We'll talk more about that in greater depth next time. But please check out rescuemichigan.com. And if you can, please support us with a contribution, because if we're going to be doing the things we want to do, it's going to take real support to be able to organize and mobilize the kind of resources that we need. Lori, I see your hands raised, so go ahead and give a question. Go ahead.
So just really quick, I was just wondering, so I know that the process is in the works as far as the legislatures, as far as cleaning up the voter rolls, but is there things that we can do, just regular citizens who might be serving with the GOP on a committee for voter integrity? Are there things that we can do to clean up the voter rolls? There's been some pushback with like the clerk and like some other people have mentioned, and people will bring in obituaries and say this person shouldn't be on the roll or should be taken off. And I understand that that is not necessarily a legal thing. But what is it that we can do to clean up the voter rolls?
Well, it starts with gathering information. And in fact, as I was just saying about building a grassroots organization, the best thing anybody can do in politics is knock on doors and connect to and engage people. And we give you voter files that include all the registered voters in the precincts, which is quite current. So if you talk to someone, you knock on their door, hey, how you doing, sir? I'm here because I'm a volunteer with the Rescue Michigan Coalition. We're concerned about the lockdowns happening in our state. We're concerned about election integrity. And we're here to organize people and get together because we've got a lot of challenges in our state. And pretty soon a conversation gets started. And maybe a door gets slammed in your face, but if not, you can start asking them, hey, by the way, there's someone with a different last name at this address. They're really here, right? Because I'm looking at a voter file and they're still listed as registered to vote in this precinct. And maybe they'll just tell you. If you find improper voter registrations in your precinct, the number one thing, first of all, yes, obviously contact your clerk and let him or her know that you've found a registration problem. If they refuse to act, I'd call them and maybe just politely say, okay, well, I'm going to check back, and this really ought to be addressed because this person just told me that so-and-so doesn't live there anymore. And there's political remedies, there's recruiting challengers. All politicians want to be reelected, and when they get angry voters, that is like poison to them. They don't want to have angry voters. Nobody does. Even the ones that are in so-called safe seats, they don't want to lose majority. They don't like having a lot of voters out there mad at them. So there are political remedies. And for all of that, the best thing is quantities of people, which involves connecting with people. And again, nothing does more for that than organizing a local organization. And like I said, Oxford Township, they have 70 people meeting every single week. That's 10 people per precinct. That's enormous influence. And the vast, vast majority of places in Michigan don't have that kind of group going. And they can be started anywhere by you, by any of you. So on that note, I think we're going to call it a night. We've had a great discussion. We have been recording. So we'll try to come up with some kind of way to release the recording in such a way that anyone who is a genuine supporter is going to get access to it, but not be too easy. We're not just going to post it on YouTube. But we're going to make this a regular thing. We're going to have a lot more of these. So expect probably next Saturday at the same time, we're going to be talking about another topic, or maybe more about this, or maybe both. So thank you everybody for joining us tonight. And again, feel free to reach out, contact us online. We're at rescuemichigan.com, sign up. And you know, if you email us, we're pretty good about responding to emails too. So I think that's it. Thanks everybody. Have a great rest of your night. Enjoy your weekend and look forward to having a lot more conversations in the future. So thanks again. Good night, guys.